we have will inform later reports that will come through our normal decision-making process through committees and the board of directors. So we want you to be aware of that. It's been a weird year, and that's going to continue into 2021. We're getting better at it, but as you can see, there are some challenges with a group the size of the Regional District Board of Directors. So hence the need for microphones and waving to get people's attention and all of the other weird stuff that I'm sure each of our 6 member municipalities are going through with their councils as well. So it is what it is, and we're going to work through it. So just a couple of things. If you see me waving, those at home, I'm trying to get Danny's attention, so he flips the slide for me. Our presenter won't reach that far, so I can't flip the PowerPoint. We do have 5 new old members coming on to the board. So we know that Katie had already been appointed a few months ago to replace Director Kimberly, who's still recovering. But with a resolution this year, the City of Penticton has changed their other 2 members. So Director Sentes will come on for Director Bloomfield, Director Watt will come on for Director Rieger. In Summerland, Director Trainer will come on for Director Boot. And in Oliver, Director Johansson will come on for Director Ventimiglia. So 5 new members on the board. Not that they haven't been with us before, some as alternates, some as members in their past as well. For today, we have 2 members right now on WebEx. We're hoping Katie can come in and join us later on or sporadically. But Director Knodel is isolating, and he is joining us from home and will be for the 2 days. So for the members at home, we don't quite have the same setup here that we have at the boardroom. So rather than using your little hands on WebEx, if you can just wave at us. Thanks. We know it's not a mannequin then for Katie. We're not sure about Rick. So we'll try and pick you up so you can enter the discussion. And we do have some breakout sessions later on in the agenda. So we are definitely going to involve those members at home, and we'll try and work through that as we do. We also have some alternates that may be joining us. We have some members of the CAO group that may be joining us either electronically or in person throughout the 2 days if they're interested in some of the stuff we're talking about. And we also have posted the link for this workshop on our webpage. So there may be members of the media or the public that join us as well. So just keep that in mind as we proceed along. This is me waving, Danny. Thanks. Now, so those were general rules. Now we have the COVID rules. So as everybody knows, we must practice physical distancing, and this is important for the lakeside. WorkSafe BC checks from time to time. The meetings rules for meeting rooms are very specific. Each sector came up with their own rules, and the province has approved them, and WorkSafe BC is enforcing them. So we want to do our part to help them out as well as stay safe. So practice physical distancing. There were some noodles around the room before to make sure we have that 6 foot distance between chairs. We have lots of hand sanitizer around the meeting room. Wear your masks if you get up. I know everybody hates wearing them, but especially those with glasses. But when you get up and move around the room, please wear your mask. And we'll try and adhere to that. We have assigned seating, so the way that COVID works, it can transmit by a touch. So if there are moisture droplets on the table and somebody else sits at your seat, they could pick that up. So stay at your assigned seat. We won't be moving for the 2 days. You're sort of locked in where you are now. So we'd appreciate if you do that. We've already seated you in accordance with the 3 breakout groups that we're going to do later. So I'm still not sure how we're going to do that with you lined up in single file. We'll see what happens. Tough to have a conversation when you're 50 feet apart. So no mingling or switching on the seats. The coffee tables, I see, are outside. So the idea is that there shouldn't be more than 6 out in the coffee table areas at one time, and there's arrows and X's and things. We have an entrance room, entrance door and an exit door, and there's arrows on the floor, so pay attention to those. It will be the same for lunch. It will be out in the lobby, and there will be hotel staff, I'm sure, that will be making sure that we don't get too congregated. Follow the arrows that are on the floor for the entrance and egress into the room. Everybody's aware the washrooms are just out the meeting room, turn to your right, and they're down the hallway. Try and, I guess, space yourself out in that as well. The emergency egress, so if we do have to evacuate the room, we will not go out the door that looks inviting with all the trees, because that has a fence around it and we can't get away from the building. So we will go out the door on my right straight through, and we'll congregate at the Peach. Obviously, if we get evacuated, it's going to be a major emergency for the lakeside, so we wouldn't want to be hanging around by the door. Microphones. Because we are so far apart, and I know, especially with Director Sentis back on the board, that we're going to have hearing problems. So please use your microphone if you do want to speak. The microphones will be live throughout the day, so watch your side conversations. Hasn't worked well for politicians in the past when that has happened, so we'll want to be careful about that. And they don't pick up sound well from a distance, so you may have to pick up your mic and speak into it, get the volume that sounds right to you, and that way everybody can adjust it to their own speaking volume. Okay, so pull it closer if you're speaking. If you do want to have a side conversation, make sure it is well away from you. And like I said, we are public, so there may be members of the media or the public on WebEx. Good. So what we want to do, I was going to talk about confidentiality. There is no confidentiality. This is an open meeting. We're not going to make decisions. We're not going to go on camera. Everything that we do, we would not meet the threshold for going in camera under the community charter. So just consider yourselves warned on that it is a public meeting, and there are members of the public that will be in attendance from time to time. So, and that would go the same then for our speakers. If there is something that comes up as we go through the items on the agenda that we need to do more research on, or that you want us to follow up on, just note that for us, please. We'll keep a parking lot, we'll keep a list, and we'll make sure that we get it back to you at an appropriate time. So we'll want to do that as well. Any questions before we get started with our first speakers? Seeing none, then what I want to do then is invite our guests to come online, and I think we have them online. So we have the BC Ombudsperson that's going to speak to us today, and also the BC Information and Privacy Commissioner. And they've given us their order. So Mr. Chalky is going to speak first, and then Mr. McAvoy, and then the BC Ombudsperson's office is going to come back in, and they have some other speakers that are going to speak to us as well. So I'm not going to give a lot of a big introduction for the speakers. I think just the fact that they're in their positions lets us know that they're accomplished and very knowledgeable in their areas of expertise. But Mr. Chalky was appointed as the Ombudsperson in July of 2015, so he's been at it for a while. He was with the office prior to that. He was within the Justice Services branch of the Ministry of Justice as well. So a long history of experience in making sure that local governments and public bodies treat their clients fairly, and that they have a right of appeal, and they have a process for that. So it's of great interest to us. I mean, this is becoming more and more obvious that we're under more and more scrutiny, and that our public have certain expectations, and we certainly do want to make sure that we're treating them fairly. So is Mr. Chalky on the line and ready to go?
Yes, I'm here.
There he goes. Over to you.
Good morning, everybody. Thank you very much for that kind introduction, and thank you for inviting me to speak to the regional district this morning. Before we begin, I just want to acknowledge that I'm presenting to you from the traditional and unceded territory of the Lekwungen-speaking people, comprised of now the Esquimalt and Songhees First Nations, and we thank them for sharing their land here in Victoria with us. And thank you to all of you for having me and my staff speak to you today. Originally, the Information and Privacy Commissioner, Michael McAvoy, and I were going to, I think, come to Penticton in, it was May or June, but the pandemic intervened, and so we're doing this virtually. So hopefully it'll all go off without a hitch. And I just want to thank Danny from the regional district for supporting us on all things IT. I do want to just express my gratitude to all of you for your commitment to public governance and public administration and excellence in public administration. Working in public administration is not necessarily the most popular field in, that one can adopt, and it comes with lots of slings and arrows, and it obviously reflects a deep commitment to help your communities that you occupy the positions you do. So just my thanks to you for all the important work that you do. So I'm going to share my screen, and hopefully I'll share the right one and not the one with the dog on it. There. Good. Okay. Thank you. As I was introduced, I'm Jay Chalk. I'm the ombudsperson for British Columbia. And I'm really going to spend the next sort of half hour describing what our office does. I'll reserve some time for questions and answer any questions you have at that point. So what's an ombudsperson? The Office of the Ombudsperson is kind of the modern iteration of an ancient tradition that goes back actually millennia, and that is that it's been common in societies for many, many years to have a public official who's responsible for receiving and entertaining grievances that people have that they're not being treated fairly. And obviously, in societies long ago, government wasn't necessarily what it is today. And so those grievances could come in all forms. But as the modern social welfare state evolved over the past 100 years, ombuds really became a focus of public governance and public administration. Some 200 years ago, the first entity known as an ombudsman was established in Sweden in 1809. And that role was to oversee the fairness of public administration, and that has been the tradition that has evolved since. It came to Canada in the 1960s. For those of you who attended Simon Fraser University, you were the beneficiaries of the first ombudsman in Canada. The student ombudsman at Simon Fraser was the first one in Canada, as Simon Fraser tried to have a new kind of university that put students at the center, and one of the ways they did that was by having an ombudsman. Then parliamentary ombudsmen, or ones established by statute, started, and the first one in Canada was in Alberta. And British Columbia's Ombudsman Act, as it was then called, was passed in 1977 and came into force in 1979. So we just celebrated our 40th birthday. So what's our role? We're established by provincial law to make sure that provincial and local public organizations treat people fairly and reasonably. And when we find unfairness, our job is to make recommendations for individual and broader redress. So really, that's it in a nutshell, but I'm not done yet. I'm going to go delve into what that means, because fairness is a pretty, it's a pretty broad term. People don't really quite, if you have to ask people to describe it, they know it when they see it, but sometimes it's hard to unpack. So I'm going to give you a sense of what our office does, and then later this morning, two of my staff, Rachel Warren and Ann Horn, are going to talk about what we can do to help you proactively make your services more fair, and thereby avoid complaints to us, but really more importantly, live up to that commitment of excellence in public service. So I'll really kind of do the broad sweep of what our office does, and then they're going to really focus on how we can help you if you're interested in sort of proactive addressing of any unfairness you might have in your service. Well, having some trouble with the slides here, but so some attributes of ombudspersons are that we're independent, we're impartial, we're confidential, and we're free. And all of those are important, and I'll touch on certainly independent and impartial aspects because those are key to what we do. So I'm one of 9 officers of the legislature. Here are some of the others you can see on the screen. The important thing to know about us is that our accountability is to the Legislative Assembly, not to the executive branch of government. So myself, for example, the Auditor General, the Information Privacy Commissioner, who you're going to hear from next hour, we're all appointed by the legislature directly, and to assure nonpartisanship, that selection is done by an all-party committee, and that recommendation or that motion for appointment has to be unanimous. So it ensures that even in a majority parliament, one party can't require or can't appoint its own legislative officer. As I said, our accountability is to all of the legislature itself. The executive branch of government, in other words, the government of British Columbia, its ministries, are just another public body that we investigate, no different than your regional district, exactly the same in terms of our relationship to them. One of the ways that independence is assured is through a fixed term of appointment. So that ensures that even if we do things that are unpopular to the government of the day, that we have tenure during the term of our appointment. We call ourselves BC's independent voice for fairness, and so independent, as I said, report to the legislature. We're neutral, so we're not advocates for complainants, and this is an important thing to know. When you hear about an investigation that we're conducting or a complaint that we've received, it can seem like, well, they're advocating for complainants because we're saying, well, here's what Mrs. Smith told us about what the regional district did. But we're recounting what she said. Our job is to investigate. So we're not advocates for complainants, and we're not apologists for the regional district. We stand between, if you like sports. We're like a baseball umpire calling balls and strikes. We don't have a team on the field. We're carrying out a statutory role. So there's something called the Ombudsperson Act, and that governs our jurisdiction. It sets out the procedure that we follow when we're conducting an investigation and the steps that we have to follow to ensure that you're treated fairly in the conduct of our work. We're very rigorous. We're very evidence-based. We just call them like we see them. We don't go in with a predisposition in favor of complainants or in favor of public authorities. We try very hard to base all our conclusions on the evidence that we receive during the course of an investigation. Turning to the other side of the slide, fairness. What's fairness? We're going to talk a little bit about that, but for those of you who were in public administration, you would understand these. The ability to be heard for someone who wants something from government. Following rules consistently and without bias, and doing so rationally and not idiosyncratically. When decisions are made, that they're clear and understandable, comprehensible and comprehensive. So how we help. We listen to people's complaints when they come to us. We investigate problems. We find solutions that are fair, and we recommend improvements to public administration. So this next slide is important because it sets out who we can investigate. And this is statutory, and our jurisdiction is institutional. So these are all entities that are identified in a schedule to the Ombudsperson Act. So when someone complains to us, our first thing we have to determine is whether we have jurisdiction. And that's a yes/no question for us. Provincial government ministries, fairly self-evident what those are. Of all these entities on the honeycomb here, about half of them are in that provincial government ministries box there. All the public school districts of the province and all the K-12 schools in the province, all the crown corporations, the biggest by complaint volume and in terms of their public profile would be BC Hydro and ICBC. Provincial government agency boards and commissions, all manner, as you know, of agency boards and commissions established under provincial law. The most notable for us by volume would be WorkSafe, the compensation scheme for injured workers in the province. The public post-secondary education system, so all the public universities and colleges in the province. All the health authorities and hospitals in the province. The professional regulators, so things like the Law Society of British Columbia, the College of Physicians and Surgeons. Those regulatory bodies established by law that are to protect the public interest in self-regulating professions. And then lastly, and not leastly, local governments of all manner in the province of various iterations, local improvement districts, waterworks districts, regional districts, municipalities themselves, so all manner of local governments. Looks like a broad jurisdiction, and it is. It's one of the broadest general jurisdictions of an ombudsman in Canada, but it's not everything. And so just to sort of clarify and understand who we don't investigate, here are probably the main ones that fall outside that group above. The biggest by volume that we get complaints about are the federal government and its agencies. Canada's a federal state. I'm a provincial legislative officer, and so I don't have jurisdiction over the federal government. But it's it's a complicated society. People don't necessarily understand how government works, and so we get lots of complaints about various things. In the pandemic, we've had lots of people concerned about their eligibility or a denial for CERB, for example. Various public service changes that have happened at the federal level. Those are outside our jurisdiction. However, there are a network. There's no general jurisdiction parliamentary ombudsman at the federal level, but there are a lot of specific ombudsmen. So, for example, if someone calls us and is concerned because they didn't receive their veterans benefit this month and they're a forces veteran, we can't help them because that's administered by Department of Veterans Affairs. But there's a veterans ombudsman who specifically looks out for complaints from veterans in Canada. So we can refer someone who contacts us to the veterans ombudsman. We're not an appeal body for court decisions. So if someone doesn't like a court decision, their remedy is to appeal that decision to a higher court. It's not to complain to the ombudsman. So my office does not have jurisdiction over a decision by court, nor do we have jurisdiction over the conduct of a judge. And so if people complain about what they perceive as inappropriate conduct by a judge, there is a provincial or a federal judicial council that can entertain that complaint, but that's not something we have jurisdiction over. We don't have jurisdiction over the police, neither RCMP or municipal police forces in the province. And that's because when you go back to that list of 9 legislative officers a few slides earlier, one of them is known as the Police Complaint Commissioner. And so that's a specialized office of the legislative officer whose job it is to superintend the administration of complaints about municipal police in the province. And there is a counterpart federal entity for RCMP police jurisdictions. And so they have a specialized office. And so it's excluded from our jurisdiction. We don't have jurisdiction over the Legislative Assembly themselves. As I mentioned earlier, I'm accountable to them, and so don't investigate complaints about the Legislative Assembly. And we don't have jurisdiction over private disputes. That's true directly. So if someone, say, doesn't get their last paycheck after working at Tim Hortons, they can't complain to us about that. But what they can do is go to the Employment Standards Branch about that. And if they go to the Employment Standards Branch about that, and the Employment Standards Branch of the Ministry of Labour doesn't do their job and investigate that complaint properly, they can complain to us about the Ministry of Labour. And so sometimes indirectly, we do get involved in private disputes. We have jurisdiction over the Residential Tenancies Branch. That's typically private landlords and tenants. So those disputes directly don't come to us, but we do entertain complaints about how the RTB dealt with a landlord-tenant matter. I mentioned before, all the regulated professions, lawyers, doctors, they're private practitioners often, but we can superintend their regulator. So we get about, next couple slides, I'm just going to take you a little bit down into the weeds of our office, and then I'll pull back a bit. We get about 7,000 to 8,000 complaints and inquiries a year, so a little over 5,000 to 6,000 are what we classify as complaints. And so what do we do with them? So basically, we kind of put them through what I would describe as a bit of a triage process. Our first point is that people can complain to us a number of different ways. They can contact us by phone. We have a 1-800 number that people can reach us. We also have an online complaint form that people can complete. People can, except during the pandemic, complain to us in person, and we do that either through our office here or when we take our office on the road and hold mobile and complaint clinics. Or they can write us letters by old-fashioned Canada Post, so any of those ways can start a complaint. The first thing we do is assess jurisdiction according to those slides I just mentioned. The other question, so assuming it is an entity that we have jurisdiction over, the next big triage step we ask people is, what have you done to resolve the problem yourself? And because many decisions that adversely affect someone have some sort of review or appeal process that's possible to undertake. And so we want to ensure that people exercise those appeal rights first and come to us after they've exhausted those remedies. So we say to them, if they haven't done it, we say, well, go do that. We're not going to investigate at this point. You go through the review process. If you're still unhappy after you've done that, by all means, come back to us and we'll review your complaint at that point. Why do we do that? First of all, it's good for the complainant. They get to maintain control over their complaint by going through the review process themselves. It's good for us because obviously we like to reserve our scarce resources for people who have exhausted other remedies. But it's also good for the public authority because if you have an unhappy customer, it's best if you're dealing with them directly and only when it's apparent that you're not able to resolve that matter. Should it need to go to someone else to get involved? So I used to run a public body for 12 years, and obviously, if one of my staff made a decision that somebody was unhappy with, I don't think the first thing I wanted was for the ombudsperson to come in and do an investigation. I would like to have an opportunity to address an unhappy customer first and make sure that we had made the right decision before that happened. So really, we do that in order to maximize both our efficiency, but more importantly, the opportunity for public administrators to make things right if things haven't gone right in the first place. But assuming that people are complaining about something in our jurisdiction, have exhausted any internal remedies that that public body might have, then we will look at commencing investigation. We have both an early resolution program that we actively use, particularly in the health and social service area, where often breakdowns in communication are at the root of problems. And so we look to be able to start and complete our investigation within 2 weeks in the early resolution program. And often it's related to reestablishing good communication between the public, the member of the public who's come to us, and whatever public body they're dealing with. But if it's obviously more complex and requires a full investigation, then it goes to gets assigned to one of our complaint investigators, or one of our ombudsperson officers who are investigators, and they will commence an investigation. Typically, and we'll talk a little bit about what that looks like, but it will involve a request for records, and then we'll go from there. So that's kind of the basic structure of what of how we do it. Now, we get all manner of complaints about public administration, whether it's a service denial, just or lack of service. People not poor customer service in the sense of not returning calls. People who perceive bias or unfairness because they feel like they're being treated in a manner that's adverse or different than other people are treated. And some people just simply don't understand. Sometimes it's not so much a complaint as a request for information. So about local government, I mentioned we received 7,000 to 8,000 complaints a year. In a recent year, 18-19, we received a little under 600 complaints and inquiries about local governments across the province. And we do, if you're interested in all things statistical, we publish an annual report, and in that annual report, we break down the complaints we receive about various types of public authorities, including local governments, and we indicate, which public authorities we receive most complaints about. I always hasten to say it doesn't mean that those public authorities that are on our top 20 list are poorly administered. Often what it reflects is big public administration. They are big. ICBC does 7 million customer transactions a year. And so every one of those obviously could end up being a complaint to us. But it also reveals that a lot of people really need government, and particularly in the areas where people need a particular decision and need it quickly. Those generate complaints, things like the health and social service field. But we do get about 600 complaints a year about local governments across the province. And by volume, obviously, the biggest governments, City of Vancouver, Surrey, Victoria, those tend to be at the top of our volume. But local government's an interesting thing, and we will see some years relatively small local governments pop quite high because there's a particular issue. So they certainly, with some of the smaller local governments, it tends to be quite an area of instability. We'll get a lot of complaints about a particular local government one year, and then that'll settle down and go back to what one might describe as more typical complaint volumes. Top areas that we get complaints about, I don't think these will come as a surprise to you: bylaw enforcement, development and zoning issues, services, garbage, water, sewer, those sorts of things, fees and charges, including taxes, property taxes, and council member conduct, things like conflict of interest. So those are kind of the areas that we do receive complaints about. What are we doing when we conduct an investigation? We're trying to determine whether or not the public body treated someone fairly. And so to do that, we're applying a section of the Ombudsperson Act that describes not fairness, but unfairness. So it's written in the negative, but it really, together, it's trying to describe unfairness, and the absence of that is fairness, obviously. So we're trying to investigate or to determine whether any of these sorts of things happened. And so this, when you start to unpack it, starts to shed a bit of light onto what do we mean by fairness? So number one, contrary to law, kind of a basic, right? If a public authority, or public authorities that are governed by laws have to administer or have to administer their affairs in accordance with that law. But what we're doing is a lot broader than that. So yes, contrary to law is one key and kind of fundamental thing that we consider, but there's a lot in the Ombudsperson Act that goes beyond to whether or not public administrators are complying with the law. So sometimes we get public administrators say, well, we complied with the statute. Right, good, that's the basics, and that's important, but there's a lot of other things that the Ombudsperson Act requires us to determine whether they've occurred. Things like whether the government behaved in a manner that was improperly discriminatory or oppressive. Did the public authority have procedures that were arbitrary? Was the public authority negligent? So a very traditional legal concept of negligence. Sometimes the issue of the service is speed, and so did the public administration happen in a manner that was reasonably, avoided unreasonable delay? Was a decision based on mistake, mistake of fact, mistake of law, and because that in itself, or an irrelevancy. So sometimes the statute will provide, or the regulation will provide, that a public authority is to decide a matter on these three considerations, and yet it's apparent that the decision was made on something that was outside of those, and thus was irrelevant to what they should have been doing. Sometimes the decision is fine, but the reasons that the public authority has given to the citizen are inadequate. So particularly in a time of tight finances, form letters, people receive a reply that says, your complaint is denied because it's not in the public interest, or your complaint, or sorry, your matter is denied because it's not in public interest, or your application is denied due to the Local Government Act, right? Obviously, that doesn't tell anybody anything about why their application was turned down, and so we look for reasons that are comprehensible to somebody and that are comprehensive. They're basically individualized reasons, so that a person can read why, if they were denied something, why that was the case. And then lastly, the Ombudsperson Act provides that we can determine whether something is otherwise wrong, which is a pretty broad jurisdiction. So you see the breadth of what we're charged with determining is quite extensive, and so we have to determine a fair range of things before we can come to the conclusion as to whether or not a complaint is or is not justified. So if we get a complaint, and as I indicated before, we have a triage process, we assign it to an investigator. If we decide to investigate a matter, and I'll just move this slide up a little bit so you can see it better. Sorry. The first thing we'll do is we're statutorily required to give you notice. So we will send a notice to your chief executive saying, we've received a complaint, we've decided to commence an investigation. Here's what the complaint is about. It's from Mrs. Smith. She contends this, this, and this. It will often also include a demand or request for records. So my office has the statutory right to compel the production of records that are held by a public body. So we'll set out what we're interested in. Please give us those records as promptly as you can. You may have other records that you think, well, that's nice they asked for that, but there are other things. By all means, give us anything else you think that would be helpful to us to be able to determine quickly and effectively and accurately a complaint. Sometimes public authorities will like to give us records that they want to give us, but not give us the records we want. Don't do that. Give us the records we want, and if you want to give us something else, feel free to give us other records as well. But what's also typical is that, or in those letters, what you'll see is we say, this is a complaint from Mrs. Smith. But we want to hear your side, right? And so that letter can look as if we're taking Mrs. Smith's side. That's the only side we've heard at that point. We want to hear your side. So by all means, take that opportunity when providing us with the records to set out anything else you think we should know. And that helps us get a complete picture, which is really what we want to obtain. Sometimes, just based on seeing the records, we'll say, now we see what happened. It's quite clear once we see the records that the complainant didn't understand what happened. We can see from the records that there was a good decision made, good process followed, and that can be enough for us. Other times, we'll need to go further. We'll need to be in touch with public authority staff to ask them questions, to resolve issues, maybe to get more records, and so it goes. But as I said, we're trying to determine whether any of those instances of unfairness that I mentioned on the previous slide have occurred. Once we have come to a preliminary assessment, one of our investigators will typically reach out to a public authority if they are of the preliminary view that unfairness has occurred, and say that we're of the preliminary view that there has been some unfairness. Here's what we would propose you do to make that unfairness right. And it might be some recommendations, and I'll talk about what those outcomes are on the next slide. But it might be recommendations related to the complainant themselves. It might be broader recommendations related to the sort of area of public administration more generally, or it might be a combination of both. On the other hand, we may come to the determination that the complaint is not justified, in which case we'll simply write a letter to you and the complainant summarizing our investigation and indicating that we've come to the determination that we don't need to investigate any further, and we're completing the investigation. So depends how much process there is connected to our assessment as to whether or not a preliminary assessment as to whether or not an investigation is justified. So, assuming that we come to the conclusion that the public authority has treated somebody unfairly or unreasonably, then we are making recommendations to that public authority to try to make it right. And that can take a number of different forms. It can look like something as straightforward as a better explanation of a decision. The decision might have been fine, but as I indicated before, the reasons might have been poor. So we might be saying, we're not recommending any change to the substantive decision, but you need to explain, you need to give better reasons. But it might be more substantive. In some cases, public authorities can hold a new hearing, and they can just rewind the clock. And so we may recommend that. That's not always legally possible, but sometimes it is. And where it is, we will make that recommendation. If a person has spent money on as a result of an unfair decision, we may recommend that those out-of-pocket expenses be reimbursed. Sometimes people say, all I want is an apology. And it used to be that apologies were not easily given by public bodies because they said, well, our lawyers say, if we make an apology, we're going to be liable. That's not the law in British Columbia. There's an Apology Act. You can apologize, and it's not admissible in any subsequent proceeding. So that's good, because an apology is an opportunity to express regret, and it can be important to people just to hear that people are sorry. And sometimes it's simply a mistake in respect of one person. Our recommendations don't go any further than the one person, but other times it's evident that the public authority treated Mrs. Smith in accordance with their policies, but it's the policies that are the problem. And so in those circumstances, we would recommend that the policy, the defect in the policy or the procedure be addressed by improving it. So it's not just Mrs. Smith's problem that gets remedied, but it's all the future Mrs. Smiths. And so that's why we often say that a single complaint can lead to changes that benefit many people. I'm going to skip a few case summaries and skip these, just conscious of time. I'm going to leave this to Rachel and Anne, but just to note that we have done a number of best practice guides and resources for local governments on issues like bylaw enforcement and open meetings. So our hope is that because there are so many local governments in the province, that these best practice guides will help you proactively address issues in administration. So, sorry about that. I'm going to, as I said, leave those, and Rachel and Ann can talk about those. And I think with that, I'll just entertain any questions that that you have.
Go ahead, Director Coyne.
Hi. Can you hear me?
Yeah.
Okay. If a local government is going to make a decision and they're not 100% sure on it, can they call your office and ask for like a review of that decision before they make it, or is that not?
Right. So we wouldn't do a pre-ruling on a specific thing, but what we can do and what we do see increasingly are public bodies that see a problem that they've often had or a procedure, and they know that there's something that they need to be doing better in order to avoid a future complaint. And so that group and that is in our office is known as our Public Authority Consultation and Training Team. And that's who you're going to hear from at 11 o'clock. So they can talk a little bit about what we do proactively, but we don't do pre-rulings on specific cases that people have. But what you can do is call us and say, you know, have you ever had this kind of complaint, and how did you investigate? You know, like what did that look like? And if it's a publicly reported matter, we can refer you to, and then you can see here's what the ombudsperson previously has said in something, you know, that you might think of as analogous.
Go ahead, Director Oberick.
Yes, and thank you. First, I want to say thank you for the excellent information. It's very informative, very appreciated. And I have two questions. The first is, are investigations public, or are they kept confidential? I can imagine it might be one or the other, depending on circumstance. And the second question is cost. Who pays?
In terms of the public-private question, the vast majority of complaints that come to us and investigations that are conducted are never publicly reported. People come to us and they're revealing obviously lots of personal information about themselves and their need for government. And so we protect that personal information, but we also protect the information that the public authority provides us, because we have statutory power, as I mentioned before, to require the production of any record. And that includes records that are not releasable under the Freedom of Information and Protection of Privacy Act that the Information and Privacy Commissioner is going to talk to you about. And so we get everything. And so we're not a conduit or a backdoor to releasing information that you would not otherwise be releasing. So it's important for your administration and also under the Ombudsperson Act for us to be conducting those investigations privately. However, back on that independent voice for fairness, the voice part of the independent voice for fairness is our public reporting. And so we do publicly report cases in a couple of circumstances. One is an annual report where we do include a selection of cases that have been dealt with over the previous year, indicating the breadth and scope of our of our investigation work and the scope of public administration that we're responsible for superintending. And so it does happen that individual cases, but in those circumstances, we're very conscious to ensure that information that's personal to the complainant, or that would identify them, or that would be difficult or problematic to release for the public authority is not included in those case summaries. The other place where information or matters are publicly reported is where when we make a recommendation, a public authority, it's a recommendation, it's not an order, where the authority declines to adopt it. That happens very rarely. Our recommendations are grounded in good investigations and in careful analysis and what we hope are practical and principled recommendations. And so the vast majority of the time, the public authority is adopting those recommendations. But where they decline to do so, the Ombudsperson Act empowers me to make a public report to the legislature to bring to legislators' attention a particular issue in public administration. So happens very rarely, maybe in a year, a half a dozen public reports like that. And in a year, maybe 40 case summaries in our annual report. And as I said, we start with 8,000. So a pretty small proportion, but yes, it does happen.
Okay, thank you. Any other questions? Yes, Director Oberick?
Just the second question on cost. I was curious. Thank you.
Sorry, I forgot about that. So the cost, so I'm assuming you're talking about the regional district's cost, because there's no cost to that we assess to a public authority related to our investigation. Our investigation is free to you. It's free to the complainant. The regional district would bear its costs, and the complainant if they have costs. And some complainants hire lawyers. Not typical, but it certainly does happen from time to time. But everybody would basically bear their own costs.
Okay, thank you. Any other questions? Okay, thank you, Jay. I think that takes us to the end of your presentation.
Great. Thank you very much for your attention. If you have any interest in pursuing any kind of proactive prevention opportunities, you'll have an opportunity to talk to Rachel and Ann later in the morning, and I'm sure they can assist you. If you ever have concerns about any matter more broadly related to our office, feel free to contact me. Thanks again.
Great, thank you.
Okay, so now we want to introduce the Information Privacy Commissioner for BC, and that's Michael McAvoy. He's been in his office since April 1st of 2018. And I should have mentioned this with the Ombudsperson as well, is that they're both appointed for a 6-year term. So Michael just sort of almost getting to halfway through his. And he's got a long history, again, with the works of information and privacy, obviously well respected in his field because he's been seconded internationally. And I've had the opportunity to hear Michael speak once before, and he's a great speaker, very informative, especially for local governments. So I'll turn this over to Mr. McAvoy.
He may need to be made as a presenter. He looks like he's listed as a participant.
Didn't sound like a Michael McAvoy. No. Oh, here we go.
Okay. All right, there we go. Just making sure from a technical point of view, can everybody hear me? Can everybody see me? Can the host confirm that?
Good to go.
Okay, that is great. Thank you very much. Thank you very much for the introduction. And as you were saying early on, I'm about 2.5 years into my 6-year term. I don't, of course, for any of us serving in public life right now, don't think any of us imagined we'd be in the middle of doing our public's business in the middle of a pandemic. But as fate would have it, I suspect for a good majority of the rest of my term as commissioner, that's a reality that I and my office will have to be dealing with, as many of you out there. Before I jump into things, I did want to acknowledge that I'm speaking to you today from the traditional territories of Lekwungen people, known here in the lower island of Vancouver Island as the Songhees and Esquimalt First Nations. I've had the opportunity to engage directly with both First Nations, myself as a school board chair in our area. So I've served in local government myself, and working with them on a First Nations education enhancement agreement, which was a great privilege to be working with the Indigenous people here. I would just say, as an aside, I think much improvement has been made on First Nations graduation rates, and that's really very positive. But it also speaks to my own experience, would speak to I'm sure, your own experience in terms of working with First Nations in your area to work on issues of reconciliation and just making life better for all of our citizens together. So I just wanted to acknowledge that at the beginning. I'm also pleased to be joining you here this morning and presenting alongside my colleague, our ombudsperson, Jay Chalk. We were both, frankly, looking very much forward to being up in your neck of the woods, live and in person. I need to say to you that my sister-in-law and my brother-in-law are residents of Asuyas. They run a gravel concrete business there, and we miss them. We've been a bit out of touch and not able to do all the things that we're normally used to doing, engaging with all of our relatives. So very much love the place that you guys live in, and I wish we were up there to do this in person. It's actually not often that Jay and I get to do these things together. So thanks for inviting both offices this morning for the work, to inform the work you're doing. I'm an independent officer of the legislature who actually wears two hats. I am the Information and Privacy Commissioner for BC, which is I'm more widely known for, but I'm also the Register of Lobbyists in the province. So people lobby the provincial government. They need to come through me and my office to register that fact. We don't have a lobbyist registry system at the regional district or municipal level yet. It's possible that may happen in BC at some point. It certainly does exist in other provinces. But for today, I'm going to be talking to you about the first hat that I wear, which is Information and Privacy Commissioner for BC. I'm sorry I missed the opening piece of Jay's talk, and I'm grateful to him because him going first allowed me to play hockey this morning, which I do on Tuesdays and Thursdays. So I'm grateful for that. I know Jay did talk a little bit about the role and nature of independent offices. I wanted to offer my 2 cents on that role. A common question I get, or a comment often from friends and relatives who say to me, "So you work for government?" No, actually, I have to tell them I do not work for government. In the formal legal parlance, I actually answer to the legislature of British Columbia, not government, not the executive branch, but to the legislature as a whole. They appointed me unanimously, and it is only they who can remove me. Hopefully they'll have no reason to want to remove me, but it would take 2/3 of the chamber to do that under our legislation. So why independent officers? I think it really speaks to the nature of our democracy, and it's about ultimately about our democratic institutions. In order to survive, really have to be trusted. And we as independent officers help to create that trust in our public institutions through the independent oversight work that we do. So where did these independent offices come from in the first place in Canada and their tradition? Well, it actually started back in the 1870s, 1872. There was an election in Canada, Sir John A. Macdonald running for a re-election, I guess it was at the time. He was embroiled in the Pacific bribery scandal. It was alleged, I think it's probably more than alleging now because there's some evidence to support the fact that those people trying to get carriage and build the railway provided many conservative ministers with money. And there was a whole question about the government books and the financing of the government books, and were they cooked, and how did this whole thing with the scandal, the Pacific scandal as it was called, how did that play into things? Well, the government, of course, said, oh, the books are totally in order and trust us. And of course, that was an issue. There was a question of trust because they had been embroiled in the scandal. So what happened as a result of that? The Office of the Auditor General of Canada was created. And what was its purpose? It was a third-party oversight body, independent of the executive branch of government, that in which people could have trust to say whether or not the books were being kept properly. The Auditor General said, yes, everything's in order. It was a way of validating the government's efforts. If the Auditor General said, no, there's some problems here, then that was an oversight mechanism. The government would get its house in order. So all going towards solidifying trust in our public institutions. Same thing that followed actually after the Auditor General was, it seems like crazy now to think of this, but back in the day, first of all, there was no secret ballot. That was considered a novelty, but elections were not run independently. So the independent chief elections officer was created in Canada to oversee elections independently and fairly. Again, all a way of reassuring the public and that they need to have confidence in their democratic institutions and conventions. Jay Chalk, of course, in his role as ombudsperson, oversees matters to ensure that government is treating people fairly. My role is also about ensuring trust in public bodies and private organizations, in that matter, from a slightly different perspective than Jay's. I'll give you an example, and one which I'm sure is relevant to many of you, and in the world of access to information. People make a request for information. Government says, yes, here's some of it, but other parts of the information we're not going to give you. We're going to withhold it because it's subject to, say, Section 22, so it's confidential information that can't be given. It would break down the trust in, I think, government fairly quickly if that was the end of the matter. I think most members of the public would say, well, might be reasons why government would want to hold that, that's suspicious. There's an inbuilt conflict of interest. That's where our office comes in. We are independent of government and able to adjudicate those kinds of matters. So if somebody disagrees with an access request made to one of your offices, they can come to us at the end of the day. I'll talk in more detail about that process a bit later. But they come to us and we say yes or no. What it does do at the end of the day, and as a legislative officer, which I feel very privileged to hold the position, is to help both the legislature, to whom I'm accountable, and the public to keep the business of government more open, more transparent, and ultimately, and this is where I think the bottom line is, ultimately more trusted by the public, because the public knows that there are mechanisms in place to keep government honest, and it makes good governance more likely. So with that, I just want to do a quick overview of what my office actually does. We were established in 1993, which seems like a long time ago. I have to say to you, for me, it's a bit like The Lion King and the Circle of Life. For those of you who have kids or grandkids and watch that movie, I was around in 1992. I was actually working as an advisor to the Attorney General of the day when the Information Privacy Act was put forward, considered to be a huge development in British Columbia around transparency and accountability of government. It's often said that the time for government to act on these things is early in a term when things are fresh. I think that's probably quite true. The government of the day, it was the Mike Harcourt government, acted quickly to bring in the legislation. I think to be frank, there were some ministers of the then government and subsequent governments that ruled the day that the legislation was brought in because of the light that it shines on government's business through access to information. All good. It was a very positive move for the province. So the two pieces of legislation that I deal with as an independent officer is the Freedom of Information and Protection of Privacy Act, probably the most well known to all of you because it covers every public body in the province, including regional districts and municipalities. The other act that I oversee is the Personal Information Protection Act. That deals with protection of privacy in the private sector, covers everything from businesses to charities to trade unions to, right across the board. Any organizations that collect your information and use it and disclose it to others. So what does my office do to that end in both the private and public sectors? We investigate complaints, we mediate complaints, and we resolve ultimately complaints to access to information and privacy complaints for that matter, ultimately through an adjudication method. That adjudication method, so a little bit different from the ombudsperson, we issue legally binding orders. So if there's a dispute between, I'll just pick one out, Penticton and a citizen about access to information, those arguments ultimately come to us, and we would make an order deciding whether information should be disclosed or not. That order is final, other than if it's appealed to the courts. Occasionally that does happen. I should just say also, as a general point, that the vast majority of cases that come to us, so if somebody wants to have a complaint reviewed, either information withheld by the district or a municipality, or there's a complaint about the processing of information, it's taking too long or whatever, the vast majority of those are resolved through a mediation process. So many of you out there may have had experience directly dealing with my office and talking to one of our many talented case review officers or investigators. Probably well over 90% of those cases are resolved in a way which is satisfactory to both the public body and the applicant. And as an independent office, I have to say we're able to leverage that independence to say to both the public body or an applicant, look, in the case of an applicant, look, you're asking for this legal opinion. We can't tell you exactly that for sure the outcome at the end of the day, but based on my experience and our knowledge, we can pretty much tell you it's really unlikely you're going to get that record. And so the other stuff, maybe at the same time, a public body, it might be have a discussion with one of our investigating officers to say, look, based on my knowledge of the case law, because they're very informed, we think this is likely to go out. We think just to resolve matters, to get those 10 pages out, I think will, show transparency on your part, is also, legally compliant. Again, those are mediation efforts. If there is a disagreement, sometimes it happens, it goes to a formal dispute resolution mechanism, and one of our adjudicators will deal with matters. I used to be one of those adjudicators. I did probably well over 50 or 60 cases in my time, and so I've had the opportunity to also adjudicate many regional district and municipal cases. So it's really interesting and important work that you do, and I do appreciative of its import. Other things that I do, I can initiate investigations that are initiated by me, maybe not come directly from a complainant. I can also audit public bodies and organizations. Where does that come from? Either maybe something I see in the media about concerns about the way a municipality, for example, might be dealing with things, which caused me to take a closer look and do an audit. So a couple of examples of that. I looked at the access to information systems that were being undertaken in the city of Vancouver. Our office did that a while back. Just had an in-depth look at their systems and found, some of it was working okay. Others needed to be fixed. The city agreed with that, and we worked with them. And again, it's it's educational, making sure that there's compliance, and it's an iterative process often between our office and your regional district or municipality to ensure that things are working properly in accordance with the Act. We also, I think, did an audit of the White Rock, City of White Rock, and the work that they were doing on access to information. Same kind of outcome. I think they found it at the end of the day to be a very helpful exercise and allowed them to get their ship moving in the right direction. I also have the ability to comment generally on access and privacy implications of proposed legislation, programs, and policy. We have a team on our policy side that works a lot with government, primarily provincial government, but not just provincial government, also public bodies, municipal governments that might be looking at changes to bylaws or the way they're doing things, or if they're looking, though I don't want to stir this pot, but for example, video surveillance systems or whatever that come to us to ask for advice about how something might function. It's really an important part of the role that I think we play is that guidance and education part that I think a lot of public bodies find really helpful, and it's something that that I as commissioner have really put an emphasis on. More recently, we comment on the privacy implications of new technology. This is obviously a huge issue. In the introduction, you mentioned I've done some work internationally, and I just through happenstance ended up helping lead an investigation into Facebook Cambridge Analytica when I was in the UK. And I have to say, obviously, the ramification of that still with us today. And as we watch things, the US election, the use of Facebook and other platforms is extraordinary. All kinds of technologies, but those technologies are not something that are some foreign to the work that government does. There will increasingly be issues of technology in government that I think we all need to pay attention to. And in fact, on that topic, the Ombudsperson and I seeing that government is starting to now, and I expect if it's not happening, it will begin to filter down into other public bodies, including your own. The world of AI, artificial intelligence, automated decision-making around certain kinds of things. There are so many challenging issues with that. Some of it has to do with protecting your data, which is used, these piles of data, your data, to help make decisions, make predictions about people is a large part of it. There's also issues of fairness and how that technology is deployed, because it can be discriminatory. Oftentimes the discrimination is built into the data that's used. It can impact human rights. So, together with other, so not just my office, but the Ombudsperson, the Human Rights Commissioner, these are issues I think all of us working in the public realm need to be concerned about. These technologies can do fantastic things, absolutely fantastic things, and aid in the work that you do in terms of policy or delivering programs. We just have to make sure that they're done in the context of protecting your data, that they're done fairly, and they respect the citizens' rights. Those technologies should work for us. We shouldn't be captive to them. And that's another thing our office does. We conduct research into things affecting access and privacy rights. Again, my work with the Ombudsperson in the world of AI is a good example of that. And of course, being out there, educating and informing the public about their rights and relevant laws. This is a very, very big part of what we do. Our staff, me included, we are constantly speaking, doing engagements across the province, and that's absolutely important. It's particularly on the, I should say, on the privacy side of things, the private sector side. For any of you out there who serve in councils but have your own private businesses, many businesses are not exactly aware that there's even privacy laws in the province that regulate how they collect and use information. So a large part of our role is to ensure that that's understood by everybody out there, by the public and by organizations that collect people's information. On that point, I should say we enforce the privacy legislation, whether it's in the public sector side or the private sector side. Through, as I mentioned, the complaints and review process, we do audits, and then at the end of the day, in some cases, we initiate investigations into matters. Probably one of the more well-known on the public sector side was the triple delete investigation that the office did a few years ago. So how does this all work operationally? Would say on the FIPA, I'm going to use that shorthand for our Freedom of Information Protection and Privacy Act, and the PIPA side, Personal Information Protection Act, we process privacy complaint, access complaints, and requests for review. And that really is the majority of my office's work. You know, to give you some perspective, I mean, we were handling, in 1993, the office was handling about 275 files, maybe in a year. Last year, the latest year, we have stats for, you know, about 14,000 files ran through the office. This, by the way, in office, our original budget was something in the neighborhood of a few $100,000. We're now about $6.7 million and have a staff of about 40. That's a pretty lean operation given the vast number of files that we handle in any year. The requests for review and time extensions, these are access requests where somebody disagrees with the way a public body has handled something, and or sometimes you, the district, will want to extend the time period for dealing with a matter because it's complex. There's a volume of information, you need more time. Last year, we handled about 5,000 of those matters. So you get a sense of the scale of the matters that we deal with. So what happens, you know, a typical example, let's say, comes in the door, somebody's gone to you, asked for some information, records. There ultimately is a disagreement. You believe that some information can go out, but other parts of those records need to be accepted, say under Section 22, because it's confidential information, or it's the personal information of individuals needs to be withheld. So what happens, it comes to our office, it's assigned to an investigator, and the investigator's role is to clearly identify the relevant issues and the provisions of the Act that are in question. The investigator, having then looked at the correspondence that come in, will then contact you and will contact the applicant, in most cases to get some additional information, to fill things out, to make sure they have a clear understanding of what's going on. The investigator will also want to make sure they have a clear understanding of what the relevant documents are, sources of information. They want to establish the facts. Investigator also will have a look in order to help guide the mediation process. We'll look at the relevant case law and we'll make preliminary findings. So when that after that happens, the investigator will then contact the complainant or the applicant, contact you to let you know what the preliminary findings are and explain, in some cases, depending on the facts, but in cases where perhaps the public body needs what the public body needs to do. And that may require maybe giving you a little more time to retrieve documents or do a process or get the appropriate records together. So, as I mentioned earlier, most of the time, that process is sufficient to deal with things probably 90+% of the time. If that is unsuccessful, the matter may proceed to an inquiry with our adjudication team, which, as I mentioned earlier, results in a legally binding order. We produce probably somewhere between 50 to 80 orders a year. And I also need to say about that investigation, or sorry, the adjudication function. It is an entirely separate wing of my office. There is, although sometimes adjudicators will talk to investigators on a social basis, they never talk about the substance of files. That needs to be kept separate. So the work that happens when you talk to a case review officer, an investigator, that's all done to help resolve matters. But those conversations don't ever make their way to the adjudicator, who looks and makes a decision based solely on the evidence before them that you will make as the public body in a formal inquiry. Why is that important? It's important because we want to make sure that it's done, that the process of natural justice is followed, that the parties have a complete and fair opportunity to be heard, and then the adjudicator then, in a sense, retires to consider the written, it's almost always a written submission, considers those written submissions, and then makes a final binding order, which again, which is binding on the parties, subject to a judicial review in the Supreme Court of British Columbia. Again, it doesn't happen often, but in cases it does. So those orders that are put out are very useful to members of the public and to yourself when you're looking to figure out, what the law requires. It's one thing to have the act, and most often the act is pretty clear and straightforward. But there are issues of, what it means to say that something is confidential or needs to be withheld because it's a solicitor-client record. There are plenty of cases, plenty of orders out there, and that can be searched on our website. You can look up keywords if there's something that relates to something in particular that you have, and you can read those orders. And I think it helps you to make a judgment about how or why or whether you should be disclosing records in certain cases. So there are instances where people request access to your records, and a public body, whichever it is, doesn't respond within the legislative time frame. Typically that's 30 days, unless it's extended and for reasons that are set out in Section 10 of the Act. But if there is no response, we treat, and it's not, there's no extension given within the Act, we treat that decision of no response as a deemed refusal under the Act. And that's, pretty significant, because it means the public body's not obviously responding as they need to under the legislation. That generally creates within our office an expedited process to look at that deemed refusal. So we'll look at it very quickly and very carefully. A case review officer will look at it. They would contact you, contact public body to look at the reasons for the delay. We'll usually discuss an estimated time for the release of the records. And this is the way it usually concludes, that if both the public body and the applicant are willing to consider a consent order specifying agreed upon time frame, that's usually the way it's done. So there's a consent order, the records will be out and dealt with within 3 weeks or whatever the case might be. It's through this process. Our aim is that public bodies have, need to be aware of and abide by their legal obligations of FIPA, and it creates some certainty, obviously, for the applicant as well. We work to build that understanding with public bodies through direct consultations with you. I mentioned guidance and educational events like this one we're doing today. We are, I can't emphasize this, and I'm sure for any of you, and many of you out there may have had direct contact with our office, we are here to help. And if you've had any engagement with any of our team here in Victoria, you will know how helpful they are. And we continue to welcome any privacy or access related questions that you have. The inbox, for those of you who don't know, info@oipc.bc.ca is the place to send them, and we get onto them pretty quickly. You've also asked me today to talk a little bit in particular about privacy on both the public and private sector side of things. As I mentioned, on the public sector side of things, it's FIPA, brought into place in 1993, and that regulates the protection of personal information under Part 3 of the Act for public bodies. So it's I guess the essence of it, and both really on the private and public sector side of things, we start from this basic proposition. Public bodies and private organizations, for that matter, can't just collect whatever they want about people. It can't be done arbitrarily. So this is, and this is where it's a little bit different in the public sector versus the private sector. So in the public sector, to collect information from your citizens, there has to be some authority to do that. You have to be able to point to something in a bylaw or a council resolution or something of that nature. And, when it comes to provincial government, they have to point to a law or regulation or something like that, which authorizes the collection of information. So, and it goes without saying, you need to be very, very careful and about the information that is collected to make sure, first of all, in the first instance, that you need to do that and that it is properly protected. It's important on both the private and public sector side, but keeping in mind in the public sector side, people in many instances don't have a lot of choice about handing their information, personal information, often sensitive information, to a public body, to government. So, for example, we all need, pretty much we all need to drive, we need a license to get on the road. In order to do that, you need to turn over a fair amount of personal information, including your image, a biometric, to government in order to do that. And so, that's been an interesting issue. We can talk about some interesting examples about how some time ago government wanted to use, or the ICBC wanted to use those images for interesting purposes, which we ruled on. Talk about that perhaps a bit later. But a good example, a recent example of authorization and a dispute about whether government had the authority to collect certain information was the speculation tax that the BC government brought in. There were concerns about government collecting your social insurance number in order to make that legislation work. Somebody came and complained about it. We of course looked at the law, made a determination about whether or not government was authorized to collect it, whether it was necessary to link a land title holding with a tax return in a reliable way in order to carry out government's objectives. At the end of the day, we ruled that in fact it did and was authorized to do that. So again, public body collecting information about its citizens, you need to find some authority in law, in legislation, a bylaw, etc. On the private sector side of things, and so this legislation on the private sector side of things brought in place in 2004. And on the private sector side of things, it's not about authorization. It's generally, not always, but generally about consent. So if a private organization wants to collect information about you, if you run a business, they need to ask your permission to collect it. And when they get that information, they are only to use it for the purpose for which it's been collected. And this is obviously an increasing issue in society as more and more information is being collected about people. How it's being used often is not very transparent. And this has led to a number of calls for our own privacy legislation in BC, which was enacted in 2004, to be improved. Just to give you an overview of how it works in Canada, there's a federal privacy commissioner, and he basically rules over data collected by businesses in a commercial way across Canada, except in 3 jurisdictions, and that would be ours, where we have substantially similar legislation to the federal government. So it's BC, Alberta, and Quebec. We all have provincial privacy legislation that are substantially similar to the federal legislation. Our offices, I need to say, work very, very closely together when there are, for example, breaches of information that happen on a national level. So a big retailer has a breach of your information. We work together to resolve matters to make sure that they're fixed. Most recently, you may have seen that we work together to investigate a company called Cadillac Fairview that has a number of shopping malls across the country. Those shopping malls and their information kiosks had embedded in them these hidden cameras that were taking people's pictures, recording that information and using it for analytic purposes. Not right. And our investigation found that that wasn't done according to law. Good example of all of our offices, Alberta, BC, and federal office in Ottawa, working together to fix that problem. So on the public sector side of things, you've asked me to talk a little bit about accountable privacy management in the public sector. which is a thank you for that. It's a really, really important issue. Again, because you have the power effectively to compel citizens to give up their personal information. It's critical that that be done in a way which respects people's personal information, and that you're accountable for it. And that really is, I think, the key word, accountability, in terms of how you conduct your operation. Because without that, without accountability and putting in place processes and programs to make sure that people's personal information is dealt with properly, it really breaks down the trust barrier between citizens and you and public bodies that are there to serve citizens. So you really do need to put accountability into practice by developing what we call a privacy management program. So a privacy management program can actually, there's not one size fits all, because some public body, I mean, even municipalities, regional districts, you differ in size. Your mandates are often relatively similar, but size and function, and even the type of information you collect may be different. However, that said, there are some fundamental building blocks we think a good privacy management program should undertake that are applicable to any public body. First, you need to make privacy a priority, and that means establishing a privacy respectful culture throughout your organization. We're not reinventing the wheel here. I need to say that we have guidance on this topic that can be found on our webpage, and our folks who work in my office are really great and can help walk you through the process. What's really, though, important, and I can't emphasize this enough, is leadership on this matter has to come from the top, right? From your chief administrative officer to the mayor to the head of a regional district. There has to be a commitment there right at the top, because that really sends a message right throughout the organization that that you're committed to protecting the information of your citizens, and that the resources are put in place that reflect that priority. In some instances, some of you will have a designated privacy officer who's responsible for a privacy management program, and that goes from its development and implementation to an ongoing assessment and review. And the privacy officer is really there to ensure that privacy protection is built into every use of personal information that you've collected as a public body. There's also got to be a reporting mechanism in place so that you can regularly monitor your compliance with the legislation. Improving privacy management is not something that can be accomplished by just ticking boxes. Program controls are essential, and here I'm referring to processes and procedures, checks that you put in place to manage your personal information. First of all, you have to understand what you're dealing with, what types of PI that you collect and use. I would just say it as simply as this: you can't protect what you don't know you have. So you've got to put together a personal information inventory. I mean, we've had occasion where we've gone in after breaches and, something's gone really wrong. And the first question we ask, of course, is what's at risk? And it's shocking sometimes the number of times somebody say, well, we actually don't know because we've never formally taken an inventory of the personal information that we have on hand. So it really needs to start with an inventory. You should be able to identify the PI in your custody and control, what authority you're using for the collection, use, and disclosure of that information. For example, looking at the relevant section of FIPA, and gauge just how sensitive the material is and what consequences could result from a breach. So a bit of a risk analysis as well. Then there's policies, creating thorough, well thought out policies that are really essential for the safeguarding of personal information in your custody and control, and ensuring a quick and appropriate response in the event of a breach. You don't want to have to figure that stuff out after you've had a breach. Look, it's not a matter of if you're going to have a breach. It comes with the territory. We hope it doesn't happen often, but it will happen. You need to have procedures in place to deal with it beforehand, so that you know who's responsible for what going forward. So the policies that you put in place, again, it's around the collection and use and disclosure of the PI, the indirect collection of personal information, the accuracy of personal information, individual access to and correction of personal information. So that's something that some of you may have run into, but people do have a right to look at their own personal information, and where they believe it's not accurate or correct, to ask that in fact that be corrected. You should also know how long you hold on to personal information and how it's disposed. You really should only be keeping information as long as you need it, really for the purposes of programs you're carrying out. You have to look at the responsible use of IT, and you need to have in place a process for responding to privacy-related complaints. So there are a few others, just before wrapping up, a few other areas important to consider to embed privacy practices in your organization, using risk assessment tools around the launch of new programs and initiatives to determine the potential negative impact of breaches, for example. Training. I'm going to stress this again because I believe it's important to foster a privacy culture, privacy-first culture in the workplace. As I mentioned, breaches are going to be inevitable, unfortunately, so you need to plan for them. You also need to manage your service providers. Remember, you can't pass off privacy responsibility simply because you've contracted somebody to do certain work. You need to make sure that in contracting people, first of all, you are still responsible for that person's information. So however your third-party provider, if it's used to process information or do whatever, you need to make sure they have the protections in place that are going to respect and treat within the legislation, treat properly the personal information that you have given over to a third-party provider. You need to let people know about their privacy rights and what you're doing to protect them, including steps to correct information and so forth. And it's important that you communicate that information to your citizens in plain language and not legalese. I would just say on this topic, we have produced an accountable privacy management program in the public sector, a resource for that we published. I think it's a really useful resource, and you can just log on to our website and get that. And then again, if there are questions about it, you can get in contact with our office. Shifting gears a bit from privacy accountability to access to information regimes and the duty to assist in proactive disclosure. Again, I have a note here that you wanted me to briefly address that. Building trust it's really important that you build trust in the access to information system that I'm sure all of you manage every day. Access to information rights have been called the lifeblood of our democracy, and I really believe that. I don't think it's an overstatement to say that, especially when considered in the context of this pandemic, when government is exercising a lot of extraordinary powers, that access rights are about ensuring accountability to the people we serve. Legislation is clear. Section 6 mandates a duty to assist FOI applicants. It requires all public bodies to make every reasonable effort to assist applicants making access requests. And I would stress every reasonable effort. The public body's response should be basically thorough and comprehensive. It's sometimes the case that an applicant sort of knows what they're after, but they don't understand exactly what it is that you collect or what information you have. So it's really important that you work with applicants to make sure that that you understand, first of all, what it is they're looking for, to clarify that. And then that way, at the end of the day, it helps everyone, because you don't want to be having to do some goose chase for records that the applicant's really not interested in. And on the other hand, it helps to ensure that the process is fair for the applicant. You, of course, have a duty to respond openly, accurately, and completely, and without delay. And I say this, it's not just best practice, but in fact, it is the law. In recent years, we've done audits of municipalities, and I think I mentioned the City of Vancouver. We did in 2016, did the City of White Rock in 2018. I would encourage you actually to even have a look at those. I think they provide some guidance to the work that we do. But some of the lessons that came from those audits, the need to provide a timely response within legislative timelines should really go without saying. To fully document each step of the FOI process from the original request to the closing of the file. Mandatory and routine training on FOI processes, emphasizing the duty to assist. That's really important. And of course, I'm sure that the FOI folks who are here today will know the patterns that develop when it comes to access requests. Certain kinds of records are requested more than others. And on that front, I think we can save ourselves a lot of time and trouble if we begin to look at what exists under Section 71 of our legislation, which is a requirement for public bodies to create categories of records for proactive disclosure. So if there's certain kinds of things that come up on a regular basis, if you can just post them, that goes, assuming that they're disclosable, goes a long way to dealing with a lot of the stuff that's asked for over and over again. In June, we released a report looking at how public bodies can categorize and communicate to the public the kinds of records that you should think about proactively disclosing. In that report, by the way, we found that some public bodies were complying with the obligation to create these categories of records. Others need to do more on that front. It's important that in establishing those categories of records that they be published and easily accessible to everyone. Again, it cuts down the work, I think, that you have to do at the end of the day. My office maybe made recommendations that we did on the provincial side about things that could be released on a regular basis, but I think there could be applicable to you as well. I don't know if any of you are doing this, but contracts over a certain amount, we said in the provincial government, contracts over 10,000, which the provincial government's now doing. There may be some other threshold for you that is perhaps more practical. 10,000 may be a practical number. Expenses for mayor and council, for example, these are things that are often asked for. I don't know if you post these proactively. It really is, I hate that old expression, but I'm going to use it anyways. It's a win-win, saves the applicant time, and it saves you time from processing these on a constant basis. Its aim is really simple, which is accountability and transparency. Again, my office is here to help on these issues. I should also say, before I just wrap this up, and I'd love to hear your questions, I just so much respect the work that that all of you do on the access and privacy side in the district and in the municipalities and city halls around the province, and the work that you do. It's really important. I know that you're committed to doing that. You're committed to helping your citizens, and it really is part of the pillar of how our democratic systems operate. I promised I wouldn't mention anything happening south of the border right now, but it does say one thing, and it does suggest, and the events of recent times have suggested, that our institutions of democracy are fragile. And so the important work that you do on the front lines, for those of you out there this morning who take in access requests and who carefully and diligently assess them and get back to members of the public in a timely way, is a really, really important part of that. And I thank you for the work that you do. I know that times it can be frustrating. I know there are times in dealing with some kinds of applicants that can be frustrating. I guess that comes with the territory, but it really, really is important work. And again, I thank you for that. You really are frontline guardians of the system that we operate in. So with that, I'm happy to take any questions or comments, actually, as well, that you may have about any of these issues.
Great, thank you very much, Michael. Are there any questions? Yes, Director Holmes?
Yes, thank you very much for your presentation. I just want to touch on the last comment you made about categorizing records. And
yeah.
As I'm sure you know, some local governments are better at doing that than others. And often, I think for smaller organizations especially, we have a lot of limitations on our data management and our ability. make that data accessible to people, and of course we're talking about a lot of money having to invest in technology to allow us to do that. So I'm just wondering if you're able to quantify that there is kind of a correlation between that transparency and making data generally accessible to the public and the correlation with the number of requests a local government might get and the length of time to process that request and everything. You know, that is that cost benefit sort of thing.
Yeah. So the first part of your issue and cost, trust me when I say that this is not a discussion that's limited to smaller municipalities. I hear it from a range of public bodies. Look, I'll just be frank about it. It's the cost of democracy, like it is running elections or whatever else. It's the people's information at the end of the day. It's your citizens' information at the end of the day. They are entitled, with certain limited exceptions, to it. So that's the cost of doing government. I also recognize, look, that these matters are scalable. My expectation of what Osoyoos is doing versus what the city of Vancouver is doing is obviously going to be somewhat different because the different scales of operation. But the basic rights of access are apply to all. I think what is happening though is that technologies are helping these matters. They are helping to make things available, perhaps that were back in the day. Somebody had to come into the town clerk and get the information. The clerk would have to go through it. I mean, we're now all capable of putting some of these records up on a website. We're all becoming more technologically proficient at this sort of thing. So I think that helps with some of the cost and disclosure requirements that make it slightly less challenging than perhaps it was in 1993 when the act was brought into place. And again, I'm going to come back to this. If there's questions or assistance that you think, or you're having challenges meeting certain kinds of requests, these discussions often happen between our investigators and your people on the front lines. And there are cases, we do look at it on a case-by-case basis. I'll be frank in saying, you may be aware of this, I extended the time period for access requests right at the beginning of the pandemic. And I have to say that particular move that I made was really more focused on smaller municipalities and smaller school boards. I was thanked by some of the bigger organizations who said, thank you, but we don't need that. But I recognized, when your frontline workers were suddenly having to go home and didn't have access to records, that was going to create a challenge. I think that now has been primarily dealt with. I think everybody, including our office, for example, we're now, operating a way which is, I think, efficient and effective, and we're adapting to these circumstances. But in that case, I recognize that there were some challenges.
Okay, thank you. I'll go to CAO Newell.
Thank you, Madam Chair. So, Michael, I sometimes get concerned about the amount of information that we release inadvertently and innocently sometimes through public hearings or through an application process at the regional district. I can say that at one point we had a development permit application from a young couple just out in a rural area around Princeton. At the time, we would list the civic address, the legal address, and the name of the applicant, trying to be as transparent as possible so that people in the area knew if there was going to be a change. At that point, we became aware that the young couple made us aware that the husband was on an undercover officer on a gang task force researching the Hells Angels down on the Lower Mainland. And by that time, the information on the name, civic address, and legal had been published not only on our webpage, but of course Google and other search engines pick up that type of information. And it is onerous to try and recover that once that gets started. Do you have any Questions as to what is required or what would be a recommendation as to what we should be releasing or how we protect that sort of information?
Yeah, so I mean, the best thing I can do is probably to point you to Part 3 of the legislation, which sets out the very basics about what you can collect, first of all. As I mentioned at the beginning, you can't just collect anything and everything that you want. You have to find some authority to do it, whether it's in a bylaw or whether it's required for carrying out a policy or program that you do. You have to demonstrate it's necessary to do that. And then in terms of its use, this is common sense stuff. I mean, you should only be using it for the purpose for which it's collected and the public understands, why it was collected. Fortunately, don't get many concerns or complaints about public bodies using data collected for purposes other than for which they were collected. And then on the final point, which is to your issue, and I'm sorry these things happen, and that's, boy, as you were saying that, I was saying to myself, yikes, that's a challenging one. The disclosure issues of your entitlement to disclose is found under Section 33 of the legislation. I won't go into it in detail, but it sets out the basis upon which you can disclose information for the purposes for which you do your government businesses. Sometimes those calls are not always easy or clear, but I think the best thing I can say to you is that where you find yourself in a difficult circumstance or not sure, my office is happy to help. And as I say, I'm sure for those of you who have had issues, sticky issues in the past, my investigation team policy folks are more than happy to help and to give you some guidance in where you think there's a gray line there.
Okay, thank you. Any other questions for Michael? Okay, I'm not seeing any. Go back to CIO Newell.
Oh, thanks, Madam Chair. So, and I'd like to express my appreciation to both the ombudsperson and the commissioner. They've done. I understand now we're going to the ombudsperson office, and Rachel Warren and Ann Horan have additional information from the office of the ombudsperson. Well, I think Danny is going to queue them up.
Great. Thank you. Danny, I just need to be able to share my screen. Great. Hopefully that's working. Great. Things around here a little bit. Well, thank you very much. I'm Rachel Warren, and I'm with the Public Authority Consultation and Training team. I do want to thank you for fitting us into your agenda today, and thanks also to Danny for all of his help getting us connected. So Jay had mentioned our team earlier. We're known as the Consultation and Training team. I've had the pleasure of being the manager of this team since we came together as a pilot program in the summer of 2017, and we're now a permanent feature of our office. And our team's role is to work outside of our office's primary investigative mandate, to work more proactively and collaboratively with public bodies to help ensure fair service delivery by the government agencies that fall under our jurisdiction. And so our team responds to requests for voluntary consultation on matters that are not currently being addressed through an investigation of a complaint. And we've worked with a number of different public authorities on their policies and programs and complaints handling processes to help build procedural fairness into the design of these. And our team has also been delivering administrative fairness training around the province now for the past 3 years as part of our program, again, trying to proactively provide education on what we actually mean by administrative fairness and what our office looks for when we're assessing complaints that come to us. Again, with the goal of proactively promoting fairness and hopefully reducing the complaints that come to you and to us as well. So we've put together a short presentation today, Anne and I, based on our full day workshop that we offer. And we were actually in the Okanagan region last spring and had a number of different public authority representatives at that workshop. So the full day workshop's been condensed to an hour. So we're going to go over some things high level and fairly quickly, but we hope that it'll give you some material as you review your governance philosophy and build on your tools to build fairness in. So in addition to the workshops and the other training, we have developed a 1-hour training program. It's an online self-paced program that's available on our website. So you may also want to refer to that, as well as a number of other tools and quick tips and webinars. So we have lots of resources on our website that as you leave here today, if you think that there are things that might be helpful to your staff or to you further, then they're all available. So Jay introduced us to the concept of administrative fairness and how our office assesses whether a public body has acted fairly in delivering their services. And when we talk about administrative fairness, what we're talking about is the standard of conduct that people can expect of us as public service providers, of public authorities really in a democratic society. There's a duty of administrative fairness expected of all of us as public service providers because the decisions we make impact people. It's really that simple. They impact people's rights, interests, and privileges, our decisions. And so there is a duty of fairness. And we know that if people can understand the decisions that are being made by local government officials, by public office officials, then they're more likely to have trust and confidence in those processes. And they may even be more likely to accept the decision, even if they don't fully agree with it. So why is it administrative fairness important in your context, in the local government context? Well, lots of reasons. They're all listed here on your screen. Certainly, fair and transparent processes lead to increased public confidence and trust in their local government, both in staff and council. People that feel heard, feel that they've been justly treated and treated fairly. And they support effective operations. We know that fair procedures and effective operations can promote efficient use of staff time and resources, supports good decision making, reduces conflict with those local constituents that you need to have those strong relationships with, helps meet legal requirements, and it's just the right thing to do as public service providers. So what is administrative fairness? How do we define it? Well, to recap a bit from Jay's presentation, he talked about what is administrative unfairness based on our act, the Ombudsperson Act. And when we talk about what administrative fairness is, it includes these sorts of things: consistent and transparent decision making. So in the context of local governments, this means sharing policy questions early in the review process, and people have time to make informed and meaningful input. It means fair and respectful treatment of all people, even-handed, reasonable application of the rules, that your policies and practices are supportive of your program goals, what they're meant to achieve. And it means that people impacted by decisions have an opportunity to be heard, and people are given understandable reasons for decisions, and that public authorities follow the regulations, policies, and procedures and follow the law. So that's really what administrative fairness is, and how we look at a complaint that comes to us where these things met. But what we found is in going around the province and sort of delivering these training sessions, we break it down into what we call the fairness triangle, which is a concept that's used by ombuds offices across the world now, really, but to sort of break down what we mean by the different aspects of administrative fairness. So what we're talking about with the fairness triangle here on your screen is the first dimension of fairness being process fairness or procedural fairness. And this side of the triangle is about following a fair process when making a decision that impacts a person or a group of people. And the procedural or process side of the triangle is about the steps the decision maker takes before, during, and after making a decision. The next dimension is the decision side of the triangle, also known as substantive fairness. So this is about making a fair decision. And was it legally sound? Was it fair? Did it comply with the rules, the law? And was it defensible and reasonable in the circumstances of the case before the decision maker? So that's more substantive fairness. And then lastly, service fairness or relational fairness. And here we're looking at how was the person treated in their interaction with the government body. And this is a really important aspect of fairness because you could have a fair procedure and a substantively fair decision, but if a person feels that that service was unfair or that they were treated unfairly in the process, they may still raise a complaint about the decision, or they may come to your office or our office. And what we know is that that service side of the triangle is often at the core of a complaint that comes to us. Also the hardest to investigate because it's these usually discrete interactions between a citizen or a member of the public and a government service provider. So very hard to investigate or prove after the fact. So that's the fairness triangle. This is what we're going to be covering in the next hour. Again, we've condensed a full day into 1 hour, so we'll be cutting quite a bit out, but hopefully we'll give you some ideas about what each of these elements of administrative fairness mean. So I'm going to cover process and service, and then Anne's going to finish us off with the decision side of the triangle. So talking about the process side of the triangle, again, this is what we're talking about. Procedural fairness. What do you as a decision maker need to make sure you do to make decisions that are fair, to follow a fair process? And again, important to emphasize, we're talking here about the process, not the substantive fairness of the decision itself. So keys to a fair decision-making process. There are two key components to a fair process, and these are born out of the concept of natural justice. And they include, the right to an unbiased and impartial decision maker, and ensuring that the person impacted by your decision has an opportunity to be heard in the process. So I'm going to talk about these two elements of process or procedural fairness. First, when we're talking about being an impartial decision maker, we're talking about the key here is really about the state of mind of the decision maker. It must be impartial, and this means the decision maker must have an open mind. This doesn't mean you have an empty mind. You bring to your work and to the decisions that you're making all of your experiences. But what we know about being an impartial decision maker, it means you're not coming with a prejudgment or a bias or leaning towards one side or another. You're open to persuasion. You're open to being persuaded on the matter that you're deciding. Unbiased really means we must guard against both conscious and unconscious biases, and we're going to talk about that in a moment. We know these biases can impact our decision making, and that the decision maker hasn't prejudged the case. So because of the routine nature of some of the work being done in public service and really in any job, we become familiar to the issues that we have to make decisions routinely on. And sometimes there's a risk of us jumping ahead or anticipating what the outcome is going to be without actually thinking through or being open to persuasion. So for example, you might have seen the same bylaw complaint come in to you regarding a neighbor dispute and might jump to a conclusion that's the same issue as last time. And really what we're saying is just reminding ourselves not to jump ahead and make that decision before collecting all of the information, the relevant information, and considering it. So when we're making a decision, we need to think about bias. Bias, this is the Supreme Court of Canada's definition of bias. It's from the Wewaykum Indian Band case. And bias is the idea that you have a leaning, inclination, bent, or predisposition towards one side or another. And really it's the idea that at some point, prior to gathering all the information and evidence, you're leaning one way or another. And this can either be favorable or unfavorable. And I think it's important to make a distinction between bias and conflict of interest. You may already be all familiar with that, but conflict of interest really arises when an individual's duty to act in the public interest is affected by a private interest. So a financial or personal gain for themselves or someone close to them. So that's what distinguishes conflict of interest from bias. We all have biases. We all bring bias to our work. So I understand that the regional district has conflict of interest policy and a code of ethics that address all of that, and that's best practice to have those kinds of policies that address conflict of interest matters. But it's important to note that it's not necessary to demonstrate actual bias in order to bring the fairness of a decision into question. because the fairness of a decision can be undercut by the perception of bias, where that perception is reasonable. And that's called the reasonable apprehension of bias. Again, defined by the courts as where a reasonable person informed of the circumstances would perceive bias on the part of the decision maker. So in addition to the legal concept of bias, which I just talked about, which is focused on preventing conscious bias from affecting decision making, there's something called implicit bias. And you may be familiar with this already. There's a lot of talk about this right now. In our current discourse. With implicit bias, we're talking about the biases we're not aware of or conscious of, and they present a unique challenge because it suggests the possibility we may unconsciously treat others differently without any awareness of even doing so, based on a set of unconscious mental shortcuts. And these mental shortcuts are known as attitudes or stereotypes. They can include both favorable and unfavorable assessments based on people's personal characteristics. And what makes implicit bias dangerous is its invisibility. They're difficult to recognize because they're often deeply rooted in our social conditioning and are often activated without any awareness. But they influence us, and they are influenced by our life experiences, all the things we've been exposed to. And making these mental shortcuts is normal. It serves a necessary purpose. We can't possibly process all the information that comes at us without having some of these implicit biases, but it's important to recognize them and slow down and consider how those implicit biases might be influencing your decision making. One way to do that is to slow down and be more mindful about what it is that we are thinking. We know that our brains have an automatic mode and are often operating quite unconsciously, kind of like cruise control on a car. But if we slow down and are mindful and can help to switch us into a more deliberate or conscious thinking, this can help to guard against those implicit biases that may impact our decision making. And an acronym that we like to use is WAIT. What am I thinking? So turning off that cruise control in your brain. What am I thinking? Am I prejudging this? Have I got a certain predisposition or prejudgment or leaning one way? And then just slowing that down and waiting until you have all the material or information to make your decision. So we've covered the first duty very, very quickly. Usually we have all kinds of activities and discussion and it's quite lively, but we don't have that today, unfortunately. But we've covered briefly the importance of having an impartial decision maker, the right to an impartial decision maker. The second duty of procedural fairness or process fairness is providing a person impacted by your decision with a reasonable opportunity to participate and to be heard in the decision-making process. This is the second key element to process fairness. So there are three key parts on when we're talking about the duty, the opportunity to be heard, which we also call as participation rights, the rights to participate in decisions that impact us. So the first is providing notice of, advance notice of, and information about the decision. So giving information to the person about the decision you have to make or you're going to be making in advance of it, and information about how you're making the decision, what criteria you're using, with enough time for them to prepare a response. Second key element is giving the person an opportunity to be heard prior to making the decision. And finally, explaining the decision to the person who's impacted with clear and meaningful reasons. But how much of an opportunity to be heard do you need to provide? Well, how much notice should be provided? This is all context dependent. Generally speaking, there's a higher duty of procedural fairness owed where there's a higher impact of that decision on an individual. So I'm going to talk about these in the next few slides here in a bit more detail. So providing notice of the decision and information about the decision, sometimes these notice requirements are set out in legislation, but in the absence of legislated notice requirements, a fair process is one where reasonable notice is provided along with information on the decision that you're going to be making. And it includes these things: providing information about the decision-making rules and criteria, explaining the decision-making process, telling the person what information you need from them to make the decision, and telling them what you know, including adverse information. This is about telling people, knowing the case before you, making sure people know the case before them that they need to meet. Also known as disclosure rights. So you should provide information, this information and notice with enough time for the person to prepare a response. And consider whether there are any circumstances or factors that might affect the person's ability to respond or to make a submission. And then again, make appropriate allowances or accommodations. So that might mean providing an extension where appropriate to allow the person sufficient time to respond. The opportunity to be heard really is about providing the person with an opportunity to tell their story, to present their case, to share relevant information and evidence that they believe is relevant, and to challenge any information you're relying on in making your decision, or correct any facts that you're relying on. And then explaining the decision and providing reasons. This is about documenting your decision, explaining it, and providing it in a clear and meaningful way to the person impacted by your decision. So they should receive an explanation and reasons for what information you considered in making your decision and why you made the decision that you did. And also that these reasons should show and demonstrate to the person that you considered their information. And it's key to ask yourself when writing a decision, if you're putting it in writing, have I demonstrated that I heard the person? And will they understand why the decision was made, even if it goes against what information they provided in their submission to me? And then providing those reasons can help to guard against arbitrary decision-making or appearing that your decision was arbitrary. And it helps to answer the why question about how you reached your conclusion. So really quickly, these are the things you want to include in your reason. What is the issue you were looking at? What was the question you needed to decide on? What facts you relied on, what you considered. In that how if you rejected certain pieces of evidence that the person submitted or placed less weight on them, explaining the reasons why that is the case. What were the rules that you were relying on, the law, policy, the eligibility criteria, whatever the rules were that guided your decision. An analysis of how you applied the rules to the facts. And again, if you can do that, you can connect the dots for people to show them how the information was considered in the context of the rules that applied. And then that leads to your decision, and then providing them with any information about available review or appeal options that they, if they're not satisfied with your decision. So that was a very quick primer on procedural fairness or process side of a triangle. These are the main things covered. And again, generally, the greater the impact of your decision on someone, the higher duty of fairness is owed. And we know that being procedurally fair supports decisions that are made on relevant considerations. If you're impartial in your decision making, then you're not going to have any personal interest. You're not going to be leaning one way or another. You're going to be objectively able to make that decision and relying on only the relevant facts and circumstances of the case. You're going to make a more well-informed decision. Being procedurally fair helps you make sure you meaningfully hear from people that are impacted by your decision and that you are getting all the information that you need to make the decision. So these tend to be, well-informed decisions. They're more likely to be seen as fair and defensible. And people, when they feel heard, they feel they've been treated fairly. So again, local governments have long-standing relationships with your constituents. So these relationships are important. So important people feel that they've been heard and fairly treated. I'm going to go now into the service side of the triangle. Again, a fundamental aspect of fairness in the way that a service is provided or received by a member of the public. and can alter the person's perception of overall fairness of the decision or action by the public body. So what is service fairness? Well, it's also relational fairness, or the human side of fairness. It includes things like demonstrating active listening in your interactions with service users, providing respectful and courteous treatment, being honest and forthright about what you can and can't do, having your information publicly available on your website and accessible to people in plain language so they can understand your normal processes, transparency in decision making, respecting people's confidential information and confidentiality generally, and providing an apology if you make a mistake. So that is sort of some of the elements of service fairness. We're going to talk about these in the context of responding to complaints, because we know that in the way we respond to a complaint is we have an opportunity to demonstrate all of these qualities that can help a person feel they've been treated fairly. So you may or may not handle complaints in your role, but if you've been in public service long enough, at some point, someone's going to come to you and be unhappy with something you or your organization did, and you'll have to respond to it. So service fairness is really about effectively managing these complaints. And we define complaints as an expression of dissatisfaction made to or about a public organization about some aspect of its programs, services, or people, where a response is explicitly or implicitly expected. Local governments will have different rules around how they respond to complaints on social media. Not every social media thing is a complaint or should deserve a response, but certainly where a response is expected, these are where you want to demonstrate that service fairness and respond in a way that makes a person feel they've been treated well. And complaints can be about all kinds of things. They usually include a concern about staff conduct or a service provided, or about a perceived unfairness or unreasonableness of a decision. Or it can also be a complaint about a previous decision or a request of review of an earlier decision. But in our experience, responding effectively to complaints is a critical component of maintaining the public's confidence in local governments and public service providers. So as we go into this next section, I want to emphasize here that we see complaints as a good thing. It's free feedback on your services. And it's important to have an effective complaints process in place so that we can get that feedback and continue to ensure a high standard of service delivery. So complaints are a valuable source of information. They're a key way to receive feedback from the people who are accessing your services and can actually help you improve your service delivery. They're a way to demonstrate respect and accountability. It's an opportunity to show that if you are responding well to complaints that come to you. And again, opportunity to strengthen those relationships that need to be maintained. So I'm going to cover 4 main principles that our office believes are foundational to effective complaints handling. We have a complaint handling guide coming out in the next couple of weeks that goes through this in much greater detail. But just very briefly, first, having a complaints process that's accessible. It should be easy for people to come to you to give you that feedback, to raise concerns. And this means making information about how to raise a complaint easy to find on your website, and making sure there are no barriers to making a complaint. So, for example, if you have the requirement that complaints must be submitted in writing, or if there's a fee attached, these can all be barriers to people raising concerns. Second, your process should be fair, and by this we mean the complaint should be handled in an unbiased way, and the person raising the concern should have an opportunity to be heard in the review process. It should be person-focused. This means being sufficiently flexible, acknowledging the person and their experience instead of your interpretation of it, and responsive. And this is about providing a timely response and resolution to the complaint wherever possible, and providing the person with information about how the complaints will be handled, and reporting back to them at the conclusion of a complaints process. So those are the 4 principles. Allows for public bodies to resolve complaints in a respectful and responsive way, and using the information that comes from those complaints to both inform the remedy and to for your own quality assurance going forward to support future decision making about how to enhance any service delivery or deficits that might be evident in your program. So one of the things that can help in handling an individual's complaint is to manage their expectations. So it's important to determine what the individual's expectations are, and as soon as possible, correct any misunderstandings they may have, because we know if people have realistic expectations about what they can expect from your organization, then they're more likely to perceive the outcome of the process or the complaints process as fair. So some wordings you might want to use to help clarify or manage those expectations of people coming to you with a complaint or concern. What outcome are you hoping for? Let me explain what happens. Some language around just helping the person understand what they can expect in the complaints process, because not all complaints obviously can be resolved, and some may be more complex and take longer to investigate. So being clear with those expectations can help. So we've gone a little bit sort of very quickly through service fairness and some of the key elements in responding to complaints, having a good complaints process, managing expectations. If through a complaint you've identified there was a flaw in their process or something that had occurred that warrants a remedy, apology is the easiest and quickest and cheapest thing you can do for, generally speaking, for resolving the issue for the person. And so whether you're responding to a complaint about an error made or just a delay or something about the service that's provided, an apology can be the most effective thing you can do to help resolve that. Apologies, we know, avoid escalation of a complaint. It can save your organization staff time and costs if it's resolved early. And from an individual's point of view, the problem isn't always the event that caused the harm, but rather it's the way the person feels they were treated after they raised the concern about what happened. So acknowledging immediately and apologizing for the mistake can be a very effective response and can avoid that escalation. Another reason to apologize is it can immediately repair the harm. It can help satisfy the needs of a person who experienced that harm. Can help to restore dignity, diffuse anger, give some peace of mind that the person who gave the apology has taken responsibility for the actions of the whatever happened or the organization's issue that occurred. And finally, it's just the right thing to do. It's good administrative practice. It's right to fix problems that we're responsible for, and it helps to decrease the chance the mistake will occur again. So you may, Jay alluded to this, you may or may not be aware, we do in BC have apology legislation called the Apology Act. We were actually the first province in Canada to enact apology legislation. And this was put in place in 2006 in part in response to the reluctance for public organizations to issue apologies. And the Apology Act provides that an apology does not constitute an admission of fault or liability, and it cannot be taken into account by any court in determining whether a person is at fault. So it's a pretty strong piece of legislation. It's a short piece of legislation, but it basically protects against statements of sympathy or regret. So things like, I'm sorry this happened to you, and also statements of fault. Things like, we made a mistake. So it makes apologies inadmissible for proving liability, but it's important to understand that giving an apology is not a means of avoiding liability altogether. A person may start an action or prove fault by other means. Basically, if you believe a mistake has been made that could give rise to legal liability, so for instance, if a person suffered physical harm or financial loss, it's important to look at that carefully and consult counsel before issuing any apologies. But basically, the kinds of things that most organizations are apologizing for at that complaint level that comes in at, are things like delay or treatment by staff or things that wouldn't give rise to legal liability in a court. And so giving an apology at that level for those lower level, lower risk kinds of errors or problems can really help to avoid the escalation of that complaint. And some things to keep in mind when giving that apology, addressing the issue directly, plain language, acknowledging the error, focusing on the organization's actions, offering reparation, and aiming to restore the relationship. Some, plain language apologies that really take that responsibility can be more effective. We've all heard bad apologies. There's lots of examples of that. So giving a good apology is important. So I'm going to just finish off here with, you've gone through all those things, you've given an apology and the person is not accepting it, is not de-escalating, it's continuing to create challenges for either your staff or is becoming more challenging in their communication to the point of that breaking down. So it's still important to continue to provide a service to a person who may be having difficulty accepting an apology or accepting a decision. And when that communication starts to break down, to have still clear and fair communication with the person. So this technique called the desk technique can help with responding fairly still to someone who may be escalating in their behavior with you. You may need to use a more direct or assertive approach if their behavior becomes more challenging or if they're not accepting what you're saying. So the desk model is covered in our guides on our website, but it suggests that this model is used to help to de-escalate someone who may be becoming more challenging in their communication, to describe, express, specify, and consequences. I'm going to go through each of these in the next few slides. So first, to describe the problem behavior. So this is, let's say, someone who is truly escalating. First, you want to acknowledge the challenge that they may have experienced and use all those methods we talked about earlier in terms of active listening. But if that is not working, if the problem behavior is creating a health or safety risk for you or your staff, the first step is to really describe that problem behavior as objectively and descriptively as you can. Specify the number of times something's happened, if it's a behavior that's created or come up a number of times, and then focus on the behavior, not your interpretation of it. So you might say something like, I notice your voice is getting loud and you're using some inappropriate language. Maybe if the person is refusing to leave and yelling and swearing. E for express. So express or explain the impact of the behavior on you. So using I, not you statements. So and why it's an issue for you. So you might say, I have difficulty hearing your concerns when you are talking so loudly. S is for specify, so asking them or specifying how the behavior could change and making a specific request in terms of what you'd like the person to do and being as specific and concrete as possible. So I would appreciate if you could lower your voice so we could talk. And then C for consequences. So stating the consequences, both positive and negative. Generally, a good idea to start with the positive. So you might say, if you're able to lower your voice, I'll be able to better focus on your concerns. And then again, if that's not working, if you're not able to, we'll have to end our call for now, and I'll follow up with you on Wednesday at 1 or by email or however you're committing to follow up with the person. So notice that you're not telling the person what to do. You're giving them a choice, and really important to follow through on that commitment if you're following through with a phone call or an email, and indicating how that is you're going to be reconnecting with them. So I think with that, I'm going to turn it over to Anne to cover the next section, which is on the decision side of the triangle, because I think we are running a little bit short of time. So Anne, I'm going to pass it over to you.
Great, thanks very much, Rachel. Well, Rachel talked about the process and the decision side of, the process and service side of the triangle, and we're going to finish up that triangle by talking about decision fairness. When we talk about decision fairness, we're talking about whether the decision itself was substantively fair, legally sound, and if it was reasonable given the circumstances and facts available to the decision maker. We talked about the duty of procedural fairness when making a decision that impacts someone's rights, privileges, or interests. But what about the fairness of the decision itself? How do we know it is fair and reasonable under the circumstances? Rachel, are you sharing my screen or your screen still?
Oh. There we go.
Okay. Can everybody see that? No. There we go. It's coming.
Sorry, everybody.
No worries.
There we go.
Excellent. So here we're going to present you a basic framework for making a fair decision. And these are lessons that we pass along to you today as an oversight body who has received some of these complaints. So the first thing to do is clarify the issue or question. Ask yourself, there you go. Ask yourself, what is it exactly that I have to decide? And it can be very helpful to articulate this not only to yourself, but also to the applicant or complainant or the requester, because it can really help to manage expectations and avoid confusion down the road when you specify exactly what it is you're looking at. And then you need to look at the relevant rules that apply. Be knowledgeable about them in order to identify specifically which section of the rules you're going to be used, because you want to be able to link your decision back to those rules. Another point to remember to make sure is that the rules themselves are fair. And if you encounter a situation where you have questions about the fairness of a policy that you're expected to follow, or when standard application of a policy appears to be resulting in an unfairness, then we encourage you to raise that in your organization. We're going to go through the remaining steps 3, 4, and 5 in the next few slides, but we wanted to bring your attention to something called quick tips. We produced these. That's just a 2-pager, and this one is on quick tips for effective communication, but we have a whole host of them on our website. Okay, so the step 3 is consider all of the relevant information. In order for your decision to be fair, it has to be based on relevant information and evidence. So the first step is to determine what information you need to make the decision and gather that information. And it could be, the information may come from a variety of sources. You may review your own documents. You may have to request additional documents from external to your organization. But the important thing is you want to have all of the information you need to make the decision. In addition, it will likely include speaking with or interviewing the person affected by the decision and possibly others who may have knowledge of the situation. This again is that opportunity to be heard that Rachel spoke about. Once the information and evidence is gathered, it's good to collate it and prepare a chronology or a timeline, because those visuals can really help you identify where any gaps are and additional information may need to be collected. The next step is to determine what is relevant to the decision that you're making and sort the evidence by its relevance to the issue that you have to decide. And you want to ask yourself here, does the evidence have a logical connection to the issues that you're looking at? Does it help you prove or disprove the issue that you're tasked with deciding? And then thirdly, you need to determine the reliability of that information. So it's easy to start with the facts that everyone agrees on, and then determine the contested facts. And here's where you're going to make a factual determination on the contested information and evidence. So you may be deciding between conflicting stories and evidence. It's important to assess whether you need to ask for more information here, but to the best of your ability, you want to verify each piece of information that you're relying on more than once if you can, especially when dealing with eyewitness or hearsay evidence, which is generally less reliable than documentary or physical evidence. And then when you're sure, you want to make sure you're considering all the relevant information and only the relevant information. Your decision shouldn't be based on evidence or information that is irrelevant to the decision at hand, because when extraneous or irrelevant information starts to be used, that's when decisions can become arbitrary and unfair. Okay, so after reviewing the relevant information and assessing the reliability of that evidence, you're now going to apply the rules to the relevant facts and put the pieces together to form your decision. Also, you want to consider what discretion you might have. Do the rules allow for discretion? We're going to talk about discretion in a minute or so. And then you make the decision on the merits of the case and provide clear and meaningful reasons for your decision so anyone reviewing it can understand how and why you got there. It's a good practice to set out decision-making guidelines in policy and procedures, in writing, for example, for bylaw enforcement, as Jay described earlier, and for other types of decision-making. I see that the Regional District is considering on its agenda today guidelines for the select committee process, but written decision-making guidelines can provide clarity to the public, to elected officials and employees about their authority, role, and procedures for decision-making, including any limits to it, which can be helpful information. So then you need to document your decision and your reasons for having made your decision. And this ensures that a record of your decision-making is available for both the people it impacts and internally in your organization. And you have to communicate that decision and the results to the persons affected and provide clear and meaningful reasons. Rachel outlined earlier what constitutes good reasons: setting out the issue, stating the facts, identifying the rules, applying them to those rules, to the facts, that's your analysis, making a decision and actually articulating it, and including any appeal or reviews decisions. You'll find additional information about what constitutes good reasons on page 17 of our Fairness in Practice Guide, which is also available on our website. And documenting is the last of those 5 steps that I introduced earlier. Okay, but let's talk about why documentation is so important. This is a rhetorical question, but have you ever had the pleasure of inheriting a file from someone else who maybe has resigned and there's hardly any documentation in it? Yes, so I think we know why documentation is important. It's the reasons that you can see up on your screen. It creates a record so it can be reviewed. It can be defended. It supports transparency, which, as Rachel said, is a critical aspect of fairness. And it preserves institutional memory, and it provides a record so that people who are impacted by the decision can appreciate it and view it as sound. Okay, now I'm going to turn to the concept of substantive equality. And I don't know how many people have knowledge of this, but we're going to break it down. So this picture, which we're going to show you, demonstrates how the concepts of equality and substantive equality differ and why it's important to consider people's individual needs. Another term sometimes used in place of substantive equality is equity, which is shown on the slide here. So have a look at this picture. What do we see? Well, in the first frame, the assumption here is that everybody benefits equally from being provided with exactly the same supports. Everyone got the same, and this would be considered equal treatment. However, what you can see is that treating everyone the same by giving them the same size box to help them view the game doesn't actually result in a fair outcome. In the second frame, you can see everyone gets the supports they actually need, where the person who needed more boxes to be able to enjoy the game got them. This means acknowledging that people have different needs and circumstances, and to the extent possible, we should be aiming to meet those needs in the delivery of public services. And the last image is one of greater justice, where all three can see the game without needing any supports or accommodations because of the inequity having been addressed by removing the systemic barrier, which was the fence. So Substantive equality is actually a legal principle in Canada, which refers to the achievement of equality in outcomes. It is achieved through opportunity and access, and most importantly, the provision of services and benefits in a manner and according to the standards that meet the unique needs and circumstances that are presented. It seeks to acknowledge and overcome barriers that have led to inequalities. Often special measures are put in place to assist the lives of those who are disadvantaged. And finally, a focus on substantive equality means recognizing that people differ in their abilities, resources, and experiences, and these differences can become barriers. So how do we apply this concept to fairness? In summary, on the topic of substantive equality, while consistency is important in decision-making, treating all people exactly the same does not necessarily equal fairness. Decision makers should follow the principle in the light blue of substantive equality, which requires that everyone gets what they need when they need, to the extent that that is possible. And fairness is measured by outcomes. Ideally, all spectators get to watch the game. So now we're going to talk just briefly about the use of discretion in decision-making. A lot of your decision-making comes down to you having to make a choice, and that is what discretion is, that there's more than one way, legitimate way that a decision could be made or an outcome could be arrived at. Discretion is basically the gray area where you have the power to choose among different courses of actions or make different types of decisions based on your professional judgment and based on the unique circumstances of the case. Administrative decision-making is often discretionary. It's signaled by the use of the word may in the rules versus shall or must. You can see the difference there. And the element of discretion allows public service employees to bring their considerable professional expertise when making decisions based on the merits of the case before them. And discretion is really important because legislation and policy can't possibly anticipate every possibility, and discretion allows for the consideration of those particular circumstances and for decisions that accommodate those circumstances. Well, how do you exercise discretion fairly? Well, first you have to exercise it in good faith, and this means you're making your decision with an appreciation of the purpose of your program and legislation, and that the decision is being made under. It also means that you're not acting with any improper or hidden motives unrelated to the decision-making criteria. The second thing is that you have to decide within the bounds of the legislation or the rules, and in a manner that is consistent with its intended purpose. The law must be applied for its proper purpose and not for any other reasons. And then finally, discretion should be exercised based on those relevant considerations. They should not be made to achieve another purpose outside of what is set out in the legislation. They should not be based on any extraneous, irrelevant, or collateral considerations. And again, we have a quick tip on on discretion, and we encourage you to have a look at that on our website. And finally, on the topic of discretion is that we want to avoid fettering discretion. Many of you will know what we mean when we say fettering, but it means limiting or restricting the exercise of discretion. And this can occur when staff bind themselves to a policy or practice that limits their discretionary power, or when their decision is influenced by the views of others such that they're directed to decide the matter in a specific way. In other words, fettering means applying a rigid one-size-fits-all approach without considering the individual circumstances and facts of each case. And we have found that we get complaints at our office about this when staff bind themselves to an application of policy rather than exercise their discretion reasonably to decide fairly. So how do you avoid fettering of discretion? Well, it is important not to apply a rigid one-size-fits-all approach. And you always want to consider the intention of the legislation or policy. Fairness in discretionary decision-making requires that you turn your mind to the specific circumstances of the case and that you're able to show how those relevant considerations were factored into your decision-making. And this may mean accommodating as individuals as needed. You might have to make an expectation to a rule or in a deserving case where the statute permits discretionary decisions. So here is a summary of what we have covered today. And we're going to ask you to keep that in mind now. In process, Rachel talked about unbiased, impartial decision-making and an opportunity to be heard, and that you have a right to have the decision and reasons explained to you. The decisions have to be consistent with the legislation, consider individual cases, and be based on relevant information. And you need to provide fairness in terms of service as well, through accessible access to information, effective communication, and an attitude of fixing errors and mistakes. So what I'm going to do now, while Rachel will keep that up on the screen so that you can consider it as I tell you a little bit of a story. This is an example regarding bylaw enforcement that's from our 2013 annual report, and it shows how inattention to small things in a complaint process can create unnecessary complications. In brief, the complainant lived in the US and owned an income property in a city, and she rented that property out. It was unsightly, so the city had some concerns and made a bylaw compliance order directing that this lady clean it up. The notice was sent by registered mail to her US address, which they had on file, and it set a 10-day limit for cleanup. However, she didn't receive the notice until the deadline day. She called the city on that same day and learned that the work had been done and she'd be billed for the cost plus penalties. After that, she visited the city and went to visit the bylaw people and explained that if there were any similar problems in the future, she would really appreciate being contacted by email, and that way she could get a very quick notice, and that would give her enough time to arrange the work. So about 6 months later, the city invested the property again and sent her another bylaw compliance order by registered mail. The second order didn't arrive by the deadline. By the time she got it and phoned the city, the work had been done and she'd been billed. So she complained to us about this. We like this example because it shows elements of both good and not so good fairness practice. The issues were whether the compliance deadlines set by the city were reasonable, since the city knew she lived in the US, and whether using registered mail was reasonable, given she'd asked for something else, and the impact of the information being in the bylaw compliance orders and the standard forms set to her, and yet the work was done before the deadline, so the deadline's kind of useless, I should say. So thinking back to the fairness triangle, in terms of process, they conducted an inspection, they provided notice, and it was to her right address. Broadly speaking, the decision to do the enforcement action was fair once they'd established non-compliance, but the issues about notice and there was an incorrect bylaw reference date as well, which created a risk of uncertainty. The city didn't appear to take her individual circumstances into account because they knew she lived far away, but they didn't modify the deadline. In terms of service, things were a little more problematic from our point of view. They jumped the gun twice by doing the work, which rendered the deadlines meaningless. They charged her before she had a chance to comply, and they didn't adjust her approach when she explained why she needed to be served in a more timely way. So that's a pretty quick and rough description of how we conduct investigations, and that was a fairly standard matter. Okay, so Rachel, let's talk about an ounce of prevention. We mentioned that we were a 3-year pilot. We want to end with some information about the consultation and training services that we offer. Rachel talked about our online webinars called Fairness 101, which is an excellent intro to fairness, and many organizations are using that now to onboard new employees and provide them with a fairness overview. We also produce publications such as the reports we discussed and the quick tips that we discussed, and we're very pleased to provide targeted fairness consultations with you when you request them of us on proposed policy, procedures, complaint processes, appeal processes, decision writing, or any fairness initiative really that you might have in hand. So we produce a number of resources. Rachel, can you go to the next slide? And we've referenced the Fairness in Practice, which is an excellent workbook. We have a number of quick tips, and we also have an administrative self-assessment guide called Fairness by Design that you might want to have a look at. We worked with offices in Manitoba, Yukon, Saskatchewan, and Nova Scotia to develop that self-assessment guide, and so that you can proactively assess your own fairness. And finally, we've been working on a complaint resolution guide, which is expected to be released this month. And this guide will offer public bodies some practical tips on setting up and maintaining an effective complaints process, and will serve as an update to something that we produced some time ago. So with that, I'm going to open it up. Does anyone have any questions or comments for Rachel or I before we get to our last slide?
No, I don't see any questions, so carry on, please.
All right. Well, what we do is to ask you to think about and discuss perhaps further throughout your day or the remaining days of your legislative workshop is what's currently going well for the regional district and within your individual local governments. Where's fairness well demonstrated in your process, your approach to service users, etc.? And where do you think that there might be room for improvement? In terms of, could be training, improving transparency, documentation changes. And so as you proceed throughout your day, we would encourage you to think back on these questions, and that the material that Jay, Rachel, and Michael McAvoy and I have presented today will help you pay attention to fairness in a continuous basis going forward. Rachel, is there anything else you'd like to say in conclusion?
No, I just want to, again, thank you very much for fitting us into your agenda. I hope the material's been helpful. Think about it, as you go through, as Anne mentioned, your review of your procedures, how you can embed fairness in, and we're here to help if you are interested in that. We've done a lot of work with a lot of different organizations and are happy to help. So let us know. That's our contact information is on this last slide. Thank you.
Okay, thank you very much, Rachel and Anne. Questions? Is that Director Knodel with a hand up?
Yeah, I have a question about applying bylaws during this COVID. Is there, we're going to run into some difficulties as COVID creates hardships on people. I'm just wondering about the fairness of bylaws without some kind of a variance to allow for the conditions of the pandemic.
That's a very interesting question. And one of the principles that we talked about today was that you need to consider the unique circumstances and facts that come forward for each decision. And therefore, if your bylaws offer you discretion, and you may have had some discussion about the kinds of hardships that people might be experiencing, you may want to take some steps slightly differently in order to accommodate that, assuming your bylaw permits that. Rachel, what would you say to that?
Yeah, I would say the same. I mean, that's going to be part of probably what you'll be working through in the next day or two, is how to adapt your normal procedures in our current circumstances, and how can you continue to maintain your operations while allowing for those accommodations or individual circumstances to be considered. What are the criteria you're going to establish for allowing exceptions? Those sorts of things are all, I think, what all public organizations are struggling with right now, is how to adapt. I don't know if we have a quick and easy answer, but I think certainly there's an expectation that some of the normal procedures will be adjusted, and that those individual circumstances will be considered if the bylaw allows that. But we're not, yeah.
Just wondering whether we'd be better off to suspend use and do it in a case-by-case basis, or just temporarily suspend certain bylaw enforcements that are probably going to lead us towards issues.
Yeah, I don't think we can comment on that. I think that's really for decisions to be made at your level. Yeah, I don't know if we can really comment on that. but certainly adjustments to normal procedures where warranted and possible would be reasonable, I would say. And looking at the impact of those decisions, thinking about like the, you know, again, what we talked about, the higher duty of fairness owed when those decisions have a higher impact, all of that to be considered. But I don't know if we can actually comment on that. Anne, I don't know if you have anything else.
No, I don't think, I mean, bylaw enforcement is generally discretionary. And so you have, I presume you have some options to exercise that discretion when circumstances make it impossible, for example, or unreasonable. Yeah, it depends kind of on the language of your bylaw and whether your bylaw enforcement policy permits any discretion.
Thank you.
Great, thank you. Any other questions before we conclude? Okay, I'd like to thank Anne and Rachel, Jay and Michael for your excellent presentations today and spending time with us this morning. So thank you again.
Thank you.
Things over to CIO Newell to give us our lunch instructions.
Thanks, Madam Chair. So we did receive the presentations from the BC Information and Privacy Commissioner and the Ombudsman this morning. I've sent those out by email to you, so you should have those for future reference. And a very interesting presentations. We do live in a legislative and regulatory framework, so knowing how to make decisions and how to treat our clients and customers fairly is important, always something that we can be informed on. So lunch is out in the lobby. Now, I know we're supposed to group only 6 at a time, so I suppose what we'll do is let's start with this table. You can go out and get your lunch, then we'll I'll leave you till last.
Yeah.
We'll go over to this side, and then this table can go last. Good choice, good. Now, we do have another delegation at 12:30, so I'm going to ask you to get your lunch and do your discussions, and then be ready to go again at 12:30. And we've got the Okanagan-Kootenay Sterile Insect Release Program coming to talk to us about cost apportionment, which we need to do before our budget discussions start next week. So consider yourselves adjourned at this point, back at 12:30.